Okay, it looks like we're at 9:59. We'll be beginning in about a minute. Mr. Jablonski, are you with us? Court reporter, Mr. Jablonski?
Excuse me, Chairman, we have a different court reporter today. It will be, we have Doug with us today.
Oh, great, thank you. All right. So, Doug, are you with us?
Yes, I am. I'm here. I'm ready for you.
Very good. Okay. Thank you. Please stand by. Ms. Best, are we ready to proceed?
We are ready, Chairman.
Very good. Well, welcome again. Thank you for, or welcome to the Maryland Public Service Commission. And today we will resume RM56 to consider regulations for the code for, community solar energy generation stations for the state of Maryland. It's very pleased and about over what we accomplished on Tuesday. It's my hope today we can wrap things up. I think we made a lot of progress, and I'm very interested to learn how things went between the parties on Wednesday. I have a couple of documents in front of me that represent new language on the issues that we brought up on Tuesday. The main areas I know we want to resume discussion is related to the subscription, I think we're calling it, coordinator. We also are going to continue to discuss brownfields and expanding the definition to include clean fill and rubble sites. Also, hopefully we'll come to some resolution on the program year dates and the amount of capacity allotted to each of those dates, and also LMI co-location waiver. So those are the primary issues, and what we'll do is go through the regulations that we marked up on Tuesday, and hopefully we'll be able to get that wrapped up maybe even this morning. First, before we proceed, I just want to just go ahead and open the floor for a moment. If there are any stakeholders with any procedural issues or any topics that they need to address before we begin and resume the rulemaking. Hearing from nobody, why don't we go ahead, Ms. Best, and why don't you put up the draft regulations that should basically list everything that we did on Friday. I'm sorry, Tuesday. Okay, thank you. Okay. So we begin in the definitions. I do want to just confirm that we have from the parties. Ms. Elder, are you going to be the primary spokesperson for CCSA today?
Commissioner Richard, this is Salar Naini. Miss Elder will not be joining us today, but I will take that on. And similar to yesterday, we'll have different parties speak on different topics.
Thank you, Mr. Naini. So right now, I believe we've arrived at the term subscription coordinator. Is this correct?
I'll let Mr. James Feinstein speak on this issue on behalf of CCSA.
Thank you.
Yep. Hi, Commissioner Richard. This is James Feinstein. Yeah, so I think we're all in agreement on subscription coordinator for the definition there.
Okay. And then I think the second issue, and Commissioner Linton, you brought this up late yesterday or Tuesday, and that is, do we need to have all the definitions and the position, I guess, description that are found later in the regulations?
Yes, it's on the screen now, Mr. Chairman. The first section was attempting to define the concept of subscriptions coordinator. And by the way, good morning, everybody. I didn't get a chance to say that earlier. So we were defining subscription coordinator in the beginning, and we really only use the term throughout this draft regulation in a number of other areas further below this section where we talk about consumer protections. And it appears as though here in section 03, we are creating some type of registration process to, I guess, track these subscription coordinators.
Mm-hmm.
So I had some concerns about, first, our authority to do that, to create this concept, and then to create a licensing or registration process for it. But then my second concern was if this process, assuming we have the authority to do it and want to proceed with it, is this sufficient? And I would lean on the staff regarding the question of whether or not they're ready for, and I know they can handle the administrative burden, but if we've truly thought through what it means to take on this new responsibility.
Okay, thanks. And I believe one potential solution, and this is where I'd like to throw this out to all stakeholders, would be in the definition. And I believe it's just with the definition of agent, we would add or subscription coordinator. And that potentially we can just get rid of the whole section that we just discussed.
Your Honor, Annette Garoff on behalf of Commission staff. I do think the Commission has jurisdiction over.
Ms. Garofalo, I can barely hear you again.
Oh, I have an extra microphone today, so I'll bring this toward me. The staff believes the Commission does have jurisdiction over this subscription coordinator. The subscription coordinator was not envisioned, at least by staff, at the outset of this program, but it appears it's become very important to the operation of the community solar stations. We recognize the hesitancy to adopt what's in the regulations now. And we would propose that it be handled in the same way that a subscriber organization is handled. And what that is handled at COMAR 2062-0202. And it's merely there we're talking about subscription organization. And to the extent we feel that a distinction is necessary to include subscription coordinators, we would just add that, and we would handle that internally. This allows a certain flexibility that by putting these items in regulations, is not there, but still allows us to track and bring before you, and also, since we went to the trouble of being concerned that complaints might be brought before CAD, to also have some way that CAD could be aware of who these subscription coordinators are. So that is staff's proposed language. Take out what is currently in there, and add subscription coordinator to this section that would essentially license, just for want of a better word, subscriber organizations.
Okay. First, before I turn to Mr. Feinstein to comment, I just wanted to go back to Commissioner Linton. Does staff proposal, would that address your concern?
I think it's moving in the right direction. I am, so just to make sure I understand what we're doing or what's being proposed, we're still maintaining the definition of subscription coordinator, but we're removing the section that creates the registration process, which is further down in the document. It was 0.03. I don't remember the rest of the numbers, but
that's what staff thinks would work. We would effectively be treating the subscription coordinator the same as a subscriber organization for the purpose of admitting them to the program. The total language is on page 14 of Amanda's new document. It's chapter 3. It's like the first page of chapter 3, and I think we've added the language there that says subscription coordinator, subscriber organization, and subscription coordinator requirements. This is just going to treat the subscription coordinator just like a subscriber organization, and they'll apply to the commission the same way that we handle the subscriber organizations, which you would think would probably be fairly restrictive as it stands, because there's an entire chapter that's sort of devoted to the customer protections associated with that. So rather than defining a separate set of application requirements, and maybe adding some additional complexity by creating that licensing, we think we should be able to do this the same way we do with the subscriber organization.
okay. So I'll ask what might seem like a silly question then, and forgive me if it does, but if we are going to treat the subscription coordinator and the subscriber organization as the same, why do we need the two different categories?
Well, Your Honor, to clarify, we're going to admit them to the program in a manner that's consistent with the way we admit the subscriber organizations. The distinction here is that while the subscription coordinator they will have their own identification number, which again I think that is the root of all of these problems. In order so that customers can recognize the subscription coordinator as a legitimate participant in the program, they will also have to display that number on their marketing materials. This entire issue came about because folks were seeing advertisements for community solar without that marketing information that's required. And they were asking the utility and perhaps asking MEA and CAD, who are these people? Should I sign up with them? And so we're essentially bringing them into the fold by giving them a number. So that's how we'll need a process to identify them, associate them with the subscriber organizations that they're working for, but they'll have their own number, and they'll probably have to post their own bond, and they'll probably need to provide us with about the same information that a subscriber organization provides, so that we can be sure that managerial and technical competency and all of the things that we look at when we're deciding whether or not an entity should participate in the program as an SO.
Right. So since we started talking a little bit about some of the And thanks for the answer. I appreciate that. If we're talking about trying to give some confidence to the market regarding how these entities operate, it's envisioned now that a customer would use the term contract with a subscription coordinator, but receive the service from the subscriber organization.
Your Honor, there's a distinction. The subscription coordinator signs a contract with or the customer signs a contract with the subscription coordinator that allows them, in this case, to execute on their behalf a contract with the subscriber organization. So we don't use the term power of attorney in here, but if you look in the top part of the new language in Chapter 5, there is a new regulation that says that they have the permission to act on the behalf of a subscriber in engaging in any of the contracting that's covered in the subtitle or that chapter. So the contract is they're basically giving power of attorney to the subscription coordinator to sign them up with a subscriber organization. So there'll be two contracts effectively. And this is essentially bringing the contract that awards the power of attorney to the subscription coordinator into the commission's oversight and regulation by creating this new function within our program.
So the customer then is not making any direct contract with the subscriber organization.
They are. It's just being done for them by the subscription coordinator. But ultimately, they've received, the subscription coordinator by these new regulations is receiving the authority from the customer to sign contracts on their behalf.
See, I guess the challenge I'm having here is, and again, I thank you for the explanation. The challenge I'm having here is that we have two different parties that are contracting with a customer for provision of the same service. And so if there's a problem with the service and the customer is going to say, you know, something's wrong with my bill, it's too high or something like that. Question that I'm having now is, who is responsible? Would it be the coordinator who set up the original contract and has what we've been referencing here today as the power of attorney? Or is it the subscriber organization that is effectively on the other end of the contract?
Your Honor, if I may, the CSEG's contract is exclusively between the customer or the subscriber and the subscriber organization. So if there's a billing issue that would be handled, that would be the customer would have that complaint about with the subscriber organization contractually.
Well, that's not entirely what I heard just a moment ago. But so what you're suggesting then is that the customer is contracting with a subscriber organization exclusively, but the contract.
For means of their community solar subscriber participation and for their community solar credits and fees and everything like that. Yes.
So why isn't it an agency relationship then between subscription organization and subscription coordinator? If the end result is that the customer receives and reviews and interacts with the subscription coordinator for all of the marketing material and all of the other stuff.
Mm-hmm. Yeah.
But then then signs with the subscription coordinator, authorizing them to sign with the subscriber organization. But if there's an issue, and at the end of the day, the subscriber organization is the one who is ultimately responsible for the debt or the bill or whatever issues arise.
So thank you for the question, Your Honor. So as commonly understood, and as I believe envisioned by the program rules, an agent neither operates under its own brand nor maintains a lasting relationship with the customer, whereas the subscription coordinator will have a distinct brand and a long-lived relationship with the customer, which is why I think that simply declaring such entities as agents is insufficient. And I think that's exactly the problem. I know in the past, some of the utilities have been a proponent of this subscription coordinator definition too, because as an agent, it's difficult to point to, again, it's difficult to know who exactly is responsible if there's a marketing question or customers have, an issue with a certain entity they're dealing with. So creating this unique entity makes it so there's someone very specific that folks know to go to if there's a question, especially on that marketing side of things. Does that help answer your question?
Well, the structure you described and Mr. Van Hayden described earlier would have made sense to me, at least, if you had told me that if there was a dispute or problem, the subscription coordinator, the one with the long-term relationship with the customer, is the one that's responsible for the problem with the account, with the contract. They negotiated on behalf of the customer. They have the long-term relationship with the customer. They're the one that had talked to the customer and told them what the arrangement would be. But if you're telling me that it's a subscriber organization, then that throws me for a loop, because now I can't understand why we inserted a third party in there. I understand why they're there, but I don't understand why we're saying that party is not responsible when they've handled the marketing. They're the one that will be, from a interaction perspective, directly interacting with the consumer, and would be the one that would more likely be the one to have, if there was a violation of our consumer protections, information that wasn't provided properly, or any of the regulations that we have, it would have been the subscription coordinator that would have engaged in any of that, because the subscriber organization is only receiving the customer from the subscription coordinator on the back end. So I'm just trying to follow along, because I see two separate licensed entities interacting with the consumer and licensed by the commission. And we don't have an ultimate one who's responsible.
So thank you for the comments and questions, Commissioner. So first, when it comes to marketing, like when there's a customer who has maybe not yet received bill credits, that would generally be the subscription coordinator who would be interfacing with that customer, and a complaint would be directly for them. And then I think, to your exact point, is depending on the relationship between the subscriber organization and the subscription coordinator, many of the subscriber organizations have an arrangement with the subscription coordinator, so that ultimately they are the one who does everything that you say, that handles that, follows up with the customer dispute and everything. But this simplifies the process, because all the commission has to do is go to the one on file. If that's the subscriber organization, then if they go to the subscriber organization with the customer complaint, either that subscriber organization handles it directly, or if they're under some agreement with the subscription coordinator, they just forward that complaint directly to the subscription coordinator, who can resolve the dispute with the customer.
So subscriber organizations, do any of them carry out the functions that we've defined here as the functions that would be for subscription coordinators?
So I can't speak for everyone's business models, but I imagine many of the functions carried out by a subscription coordinator are carried out by some vertically integrated subscriber organizations who build and operate projects and manage and acquire customers. But not all do, which is the reason for the whole subscription coordinator role that currently exists in the market today.
All right, I've asked several questions, Mr. Chairman. I don't know if either you or Commissioner O'Donnell, if either of you have any thoughts as well.
So, Commissioner Linton, are you finished with your questioning at this time?
I am. I have to say that I'm not entirely comfortable with it at this point. I think that I can understand how the industry's developed to get to this point, and I appreciate the language that staff has provided this morning to try and bring it a little closer to something that is along the lines of what we do currently. That does address some of my concerns on the administrative side, if we follow the approach in the direction that we're following now, assuming that on the front end we have the authority or to basically create a separate category and treat it as if it's from a licensing perspective the same as a subscriber organization. So administratively, it would do the same thing with them. So subscriber organization is a statutory term, subscription coordinator is not. But we're treating the two of them like they're the same from our administrative perspective. As long as that process is something that we can do, then, and the staff is confident that we can, then on the administrative side, that would address some of my concerns there. Just really wanted to make sure, since that was not the language that was here earlier, that was not proposed by the staff, that they had the opportunity to think through administratively how that would actually work. And what our responsibilities as a commission would be for maintaining it on a website and tracking how many subscription coordinators they could be that apply. Could it be 5 or 10 or 5,000? So, just making sure that that process has been thought through. And so I will rely on staff's representation that they're comfortable with the structure that exists currently for subscriber organizations. On the question of whether or not it actually fits the overall scheme, I'll listen for additional comments from other parties. I'm still a little uncomfortable with it. I understand that that's how the market's developed up until this point, but I can see situations, for example, where if there's not one that's ultimately responsible in our regulations, and that's kind of the benefit of having an agency relationship. I understand that agency is it appears to be a term that doesn't really fit here because of the marketing, et cetera. But from an administrative perspective, it makes it clear that there's one party that's ultimately responsible. We do have, on the retail side, we have parties that also utilize companies similar to subscription coordinators. We even had companies that attempt to do something similar to what subscription coordinators are proposed to do here. And even in those instances, we have the same result, which is that the retail supplier is ultimately responsible. That's the entity that faces a fine from the commission if there's a violation of our regulations. Here, I'm not quite sure who that would be. And I could see a scenario where if the problem is large enough, where you could have both parties saying it's the other guy's fault. And I don't know that we'd want to set up a regulatory structure that would encourage something like that. So I'll listen for some other thoughts and comments to see if there's a middle ground here. I'm not sure.
Yeah, no, thank you, Commissioner Linton. I think these are important questions. I guess for me, I'm trying to figure out how do we align our program in Maryland with the business structure that as it works in other states, but of course it has to be uniquely fit within our regulation. So I think the key question that I heard Commissioner Linton ask, can I ask Mr. Feinstein, and also Mr. Vanderheyden, who is the ultimate responsible party? At this point, it was been my belief that it was the subscriber organization. Is that correct? And can we say that definitively? So in the circumstance that Commissioner Linton describes, we don't end up in a finger pointing, but we know who the ultimate responsible party is.
Yes, that's exactly right. That's why the customer's ultimately their CSEG's contract and their subscriber agreement is directly with the subscriber organization. So I think at the end of the day, that's the one that's the entity that's ultimately responsible. But yeah, and we are okay if that needs to be stated more clearly in the regulations.
Is Mr. Vanderheyden, do the regulations state that now, or is there something we can do to address that issue? And I want to go back to Commissioner Linton. Is that correctly? Is that the key issue that we need to address at this stage?
I think that's the ultimate issue, Mr. Chairman. It's again, I'm relying on a number of other issues that I raised earlier to have been resolved. But if we're talking about the question of making sure consumer protections apply, and we've added the term subscription coordinator throughout the consumer protections further down in this draft. And I'm fine with that. And I'm not opposed to the concept or the business model of the subscription coordinator. I just want to make sure that we don't have a subscriber organization say, hey, this subscriber coordinator was supposed to adhere to the terms of COMAR. It says so in COMAR, but they clearly slammed a whole bunch of customers. So it's not our responsibility, even though we're the final party on the contract. The subscription coordinator has to follow those regulations too, and they did. So it's their fault. You should find them and not us. And then we get into questions of whether or not the subscription coordinator is subject to 3102 proceedings by the commission, absent of the subscriber organization's participation. And so then that's where some of the other concerns that I raised earlier come out. So it ultimately comes down to making clear in the regulations that for all disputes, regardless of whether or not the subscription coordinator was in violation of our regulations, that it's the subscriber organization that's responsible. And that ultimately is an agency position. I mean, that's what agency law says. If this entity is working on your behalf, you're responsible for them while they're working on your behalf. And that's the clarity that I'm hoping we have in the regulation.
Let me turn back then to staff. Mr. Vanderheyden, do you believe that the regulations as currently drafted do that, or is there language we can add to address Commissioner Linton's desire to see it clearly designate a party as the ultimate responsible party?
Your Honor, I don't think that the regulations are as currently drafted are like very clearly providing the responsible entity in. But if we take the example of slamming that Commissioner Linton mentioned, that slamming would have to occur, I suppose, if a subscription coordinator signed a customer up with a subscriber organization without properly executing the power of attorney contract that's described. So in that regard, you might imagine that the subscriber organization would say, well, you know, we executed a valid contract, you and the entity that told us that signed the customer up was the subscription coordinator. And then, so was the damage occurring in the rate in the contract that was wrong, or that was, or the terms, or was the damage occurring when somebody improperly took power of attorney? And so that would get messy, I think.
I hear that. So is there language we can, you can suggest, and Mr. Feinstein could suggest to clarify this point, that the subscriber, it's the organization, subscriber organization, the ultimate provider of the service, is responsible for the coordinator.
I suppose we could take an attempt to draft it. I don't think I can't think of something like that on the fly at the moment. But if you would like,
I don't want to do it on the fly, but I'm hoping that is something we could, this morning or by early afternoon, resolve. Mr. Feinstein, is that something we could resolve?
I believe that's something we could, we're happy to work on that. If the commission is interested in that, happy to.
Yeah, and I'm sorry, Commissioner O'Donnell, I didn't want to leave you out. Are we going in a direction that you support?
So clearly, the commission, when it comes to retail suppliers, has said the supplier is ultimately responsible for people in the field acting on their behalf. And I think we need to be consistent here in the same way. To be able to hold the subscriber organization responsible, we don't want to have a situation, we hear all the time from third-party suppliers that say, well, we had a rogue, person in the field and they violated the rules and we severed our relationship with them, so don't hold us accountable. We don't want that situation. We want to be able to clearly hold the subscriber organization accountable, because they're, in my mind, they're ultimately responsible for people working on their behalf in the field. And so to the extent that we need to clarify that, I think that's important, because the subscriber organization is who the commission's gonna hold responsible if we stick to precedent and the model we use for retail suppliers. So I think it's important. I think it's relatively easy to fix. And I think Commissioner Linton brings up a good point. We need to be clear on this, that although we're giving some authority to a subscription coordinator, they're simply acting on behalf of the subscriber organization, in my mind, who is ultimately responsible. And I think that's important for the commission to have going forward. The other point I'd like to make is that staff seems to want to administratively control this subscription coordinator in the same manner that they control the subscriber organization administratively, with forms produced by staff and et cetera, to keep it simple and administratively control it kind of in the back of the house. And that's fine by me. I think that can be done, but the important thing there is that it be done consistently across the board for everybody. Fundamental to rulemaking is that everybody's treated the same, and the danger in not specifying it is some are treated differently than others. And that, so as long as staff has the confidence that they can consistently manage that in the back of the house, I'm okay with it, but it needs to survive over time in a consistent manner. So those are the 2 points that I kind of wanted to put out there. But you know, Commissioner Linton brings up a good point. We need to be clear on who we're holding accountable for these contracts.
Thank you, Commissioner O'Donnell, and I do agree. Okay, on this particular topic, let me ask if we can, if the parties can come together with some language. We'll continue moving through the draft regulations, but you know, perhaps we can take at 11. 11:30 or so, a break, maybe an extended break of 30 minutes or so, and see if we can tighten up the language here that addresses the you know, and clarifies that the subscriber organization is ultimately responsible. So just before we move on, Commissioner Linton, would that be I guess sufficient for you to be supportive of this overall, this section or this concept of the subscription coordinator?
Yes, Mr. Chairman, with the caveats that I mentioned earlier, that the staff is comfortable administratively, and that as has been represented here today, and that we do have the legal authority to create and license this particular category of a person, which I guess doesn't necessarily have to be a company, but so a type of entity.
Very good. Okay, with that, are there
Mr.
any
Chairman,
other...
could I offer a couple comments from the utility perspective?
Sure, Mr. Herson.
Sorry, thank you. I'll be very brief. I just wanted to say, if the goal, and you know, building off of Commissioners O'Donnell and Linton's comments, if the goal is that ultimately we want to make the subscriber organization responsible for customer issues, customer complaints, I think it's going to be very important for our customers and the utility administering our programs that we have full transparency into what particular subscriber organizations or projects that the subscription coordinators are affiliated with or are working on behalf or have any association with. So I would ask that maybe we consider, I know staff wanted to delete 20620309, but there's a couple provisions in there, specifically subsection C and D, that talk about notifying the commission of the projects they're associated with, as well as making the list of subscription coordinators available on a website for everybody to see, that I think have some value and we might consider retaining.
Thank you, Mr. Herson. Mr. Feinstein, let me turn to you first. Is that something that CCSA would be able to support?
Your Honor, yes, we've supported that in the past and we continue to support that. And yeah, we really appreciate the comments today. I agree wholeheartedly with Commissioner O'Donnell's analogy to the retail supply market. I think that's exactly right. We're already seeing our teams work on some draft language that we think will satisfy the concerns here today. And then lastly, also to Commissioner Litton's concern about commission authority, yesterday morning or late morning, CCSA did submit, or we filed a docket in the RM56 docket, highlighting multiple places where we think that explain how the commission has broad authority to create a new entity. So we hope that can help satisfy your concerns, and happy to discuss that more later if that's of interest. So
Thank you, Mr. Feinstein. Mr. Vanderheyden, you have any?
Yes, Your Honor.
Is this language that we can, I guess, restore? And is after this, excuse me, the discussion you've heard, is that something that the staff would could be supportive of?
Your Honor, I think our concern with this language was that it wasn't enough and wasn't the full amount of review that we take with a subscriber organization. So the language as it's written says shall register, and then it says the registration shall consist of. It doesn't say anything about a form that's authorized by the commission, which is what the language over in chapter 3 talks about. So certainly I don't think we have any objections to this information being provided. We would certainly, collect almost all. I think we'd collect all of this under the authorized forms, and then the requirement to notify the utilities. That's a good requirement. There is a requirement here that the commission shall make this list available under the commission's website. I think staff typically avoids binding the commission to certain functions in regulation, and we certainly the commission could choose to do that. I don't think it's necessary for that to be a requirement of the commission. I think we would do that if that's what made sense, and at some point it might make sense for that to be provided by a third party or something. But otherwise, these are all good things to have. We just think we would probably want more than what is listed here, because that's what there are more things than this is what's collected by the subscriber organization. In particular, there's a bonding requirement that we use to ensure that there is compliance and also recourse if there are civil penalties and things of that nature. So we would hate to be operating a subscription coordinator in this regard without those same requirements and obligations. So this can stay, but we would change it to make sure that this isn't all that's required.
Okay, so essentially it's yes for restoring this language, and then administratively, did I hear you state that you could work with the supplier organizations to get this additional information?
We would. So the way we authorize a subscriber organization now is that there are forms which the regulations require to be authorized by the commission.
Right.
Okay.
So I just wondered how do we get this additional information that you say is not encompassed within the language that we're talking about restoring?
I think what we intended to do here was to modify the existing application for a subscriber organization and do one of two things: either create a separate application for a subscription coordinator that is more or less modeled on the same information that we obtain using the subscriber organization application form, or we would simply modify the form and add an additional box or section that indicated that the applicant was applying to be a subscription coordinator. Because I think entities that are actually, as someone noted, that are operating as both of those things right now. So we would sort of have to figure out, do we need a separate application for them, or do they just indicate that we're also functioning as a subscription coordinator, et cetera? So we have forms. The commission, I think we handled approval of those forms through a filing we made with the commission that may have gone to an admin meeting or something of that nature.
Okay, so with the restoration of language and with the forms, with I guess amending these forms, that satisfies staff information requirements. Is that correct? Just yes or no?
I believe yes.
Okay.
Mr. Vanderheyden, Mr. Vanderheyden, let me ask you a question. I've heard you allude to bonding several times now, and I think it was in relationship to the registration or application of the subscription coordinator. Am I hearing you right on that?
Your Honor, we are thinking that the subscription coordinator would also be required to post a bond in the same way a subscriber organization is.
So that raises in my mind something contrary to what I said just a little bit ago, and that kind of conveys responsibility to the subscription coordinator when I was articulating that I think the subscriber organization should ultimately be responsible. In other words, we don't make third-party suppliers go out and bond every person knocking on doors or trying to sign people up for their third-party supplier, and yet you're saying we're going to do that here, and that kind of, to me, entails holding accountable not only the subscription organization, but also the subscriber organization, but also the subscription coordinator, who would be liable for proceedings. And that's where you get the finger pointing. We got a rogue coordinator out there, and they're responsible. They're bonded, they're licensed, they're registered, and you need to hold them accountable, not us. And that creates a lot of problems when you have a situation where it's not clear who is to be held accountable for these people acting on behalf of a subscriber organization.
I apologize, Your Honor. I think maybe I misunderstood, but remember how we were calling this a broker originally? I think there was a concept that what we were dealing with here is not like a door-to-door agent, a sales agent, but an actual broker. And so I think we were still that part of that concept is still here. And I think what we are sort of tasked with over the break is to try to look at this language. If the commission's direction is to, make this effectively an agent that has its own brand, and that we probably need regulations that bind the subscriber or subscription coordinator such that, or rather bind the subscriber organization so that if they sign a contract through a subscriber coordinator, that ultimately the subscription broker, is responsible for any of the actions as if they are an agent of the subscriber organization. So that I don't think we've sorted all that out yet.
I think we're trying to get to the point where the organization is the ultimate responsible. And I agree with Commissioner O'Donnell. This just starts to muddy the water again. So the organization is responsible for their coordinator, even if that coordinator is working for multiple organizations. That's where I believe we're trying to go. Is that correct, Commissioner Linton, Commissioner O'Donnell?
I think that's right.
Yeah, I think that's correct. In response to the comment from Mr. Herson from BGE, what I think he's pointing out is that the information in sections, the language that's on the screen now, the information that would have come through the registration process that was originally proposed under sections C, D, and E is information that is, I'm sorry, not C, D, and E, just section C, is valuable to the utility company. That's the information regarding the CSEG projects, and that would be as valuable to the utility. So I think if with the proposal that the staff made earlier this morning to treat subscription coordinators like subscriber organizations, the staff, as part of the administrative process, would just have to ask for that additional information during the licensing process so that the subscription coordinators know that whenever they have a project they're working on, they have to update the staff about it, so the staff will know. The question of whether or not it's posted on the commission's website is one that, as I said before, I have to defer to the staff on in terms of managing this type of application and registration process. Assuming the staff is comfortable doing that and has some structure in place that they can rely on to do it, then I would be comfortable with it.
For me, Mr. Chairman, just for me, if we come back with language or staff comes back with language or the stakeholders come back with language that doesn't make it specifically clear who's to be held accountable for faulty contracts or for illicitly obtained contracts, just like in the retail world, if it's not clear who is responsible, you're creating a litigation nightmare down the road because both parties are going to point to the other, and you just can't administer a program where it might be the coordinator, it might be the organization, and it's hard to decipher who's actually accountable. We have to be clear as to who's going to be held accountable for problems down the road, if and when they should arise. And I'm a little uncomfortable with what I hear Mr. Vanderhayden saying right now. So
Thank you, Commissioner O'Donnell. And again, I started with the presumption that the organization was responsible, and after this conversation, I'm in full agreement that we need to make clear that the subscriber organization is that ultimately responsible partner, so we don't create some of the confusion and litigation risks that you raise. So appreciate that, and with that, I think we provided some.
May I ask a question two questions for clarity? I heard Commissioner Linton say that he wanted us to track each subscriber organization that the subscription coordinator was working with. And then I heard Commissioner O'Donnell say that he wanted the subscription coordinator to be responsible for anything that went wrong with a subscription that was assigned to NSO.
no, I didn't say that.
All right.
I said I thought it was important that the organization be the responsible party, and they're responsible for the actions of the coordinator acting on their behalf.
Okay. So
and I didn't say that either.
My position also.
That's also my position, and I did not say that. That was Mr. Urson's position, that the information in the information on the screen now, section C, and if he's still on the hearing, he can certainly speak for himself. But I believe he was the one that was suggesting that this information would be useful to the utility company. So we were attempting to gather that information. I don't think we need to restore all of this language. The staff could simply incorporate it into the licensing process that they use now, just to modify the forms or something, to make sure that we capture it, assuming that we agree that it's necessary. That's okay. Yeah, I was just Mr. Urson's statement. I was simply commenting that we didn't have to restore all this language in order to achieve that point, if that's a point we want to achieve.
If I could just one clarification question also, just I think I understood what I heard, just to make sure I get this. So when we do this language, if a customer is, and I don't want to say slammed, but if they believe that their power of attorney was taken or granted in a manner that they did not agree with, that has nothing to do with the contract that that are signed on their behalf with the subscriber organization. I think that's how that works. If that is the case, is it the commission's intent that the subscriber organization who signs a contract through the subscription coordinator is responsible for the slamming that occurs if the customer is alleging that they were signed up without their authorization? So the power of attorney, the grant of the power of attorney to sign with the subscriber organization, that if the customer is complaining about being slammed, that subscriber organization, and I suppose any subscriber organization that customer has been signed up, and there could be more than one, is on the hook for whatever the judgment is or the determination of the commission is. I think that's what you want to happen. I just want to make sure we draft the language correctly.
For me, that's exactly right. The subscriber organization creates the relationship, in my mind, with the subscription coordinator, and they're responsible ultimately for their actions. And if the subscription coordinator creates something faulty on behalf of the subscriber organization, it's the responsibility of the subscriber organization, because they created the relationship with the coordinator, just like in the retail world. And now you know clearly who's responsible. And it's none of this, well, it was a rogue coordinator and they screwed up and they need to be held accountable and they need to exercise their bond. You need to exercise their bond and all that. That's just a nightmare if you create a scenario like that, I'm telling you.
Your Honor, CCSA has a proposed amendment, a very minor red line to 20.62.05.15. If we simply add subscription.
Could you hold 1
coordinator to that
second?
section.
Could you let Ms. Best get to that section and capture
Yes,
the language?
absolutely. I'm sorry.
Sure.
And it's also in the chat if that's easier. So 20.62.05.15.
And just may I ask Mr. Feinstein, for efficiency, is this something that may be best discussed first with staff and maybe brought back at after a break, or?
If we're open on that. I think it's a very simple one. I think if we put it out here, staff can then review maybe over the lunch or over the 11 o'clock break.
Okay.
But okay, so I think here in this section .15, a subscriber organization, if we remove this or subscription coordinator part, then a subscriber organization may use an agent or a subscriber coordinator to conduct marketing and sales activities. And then actually, sorry, it's this section right above it. Subscriber organization is responsible for the actions of its agents or subscriber coordinators. If you just change that section, you just add that small addition and subtraction. Yeah.
Okay. Okay. Mr. Vanderhayden, do you want to react to that? And then, of course, I want to hear from commissioners if this simple edit is sufficient.
Your Honor, I think we're probably going to want to think a little bit about that. What I'm getting is that, effectively the subscription coordinator is going to, for all intent and purpose, be an agent of the subscriber organization. It's just that we've kind of created this, they get to be an agent for multiple subscriber organizations and they have their own brand and number. So somehow in the definition of subscription coordinator, where we had removed language that said they were an agent, maybe that needs to come back in. And there's so many places in Chapter 5 where we probably want to make sure we've covered everything. But if everybody understands that the actual intent here is that if there's ever a problem with, in particular, slamming, I think is where you run into this sort of thing, but there could be other types of problems. The subscriber organization that ultimately has the contract with the customer is the one that's going to be responsible. And so that means that they actually need to sort of indemnify the subscription coordinator, such that if the subscription coordinator is found to have done something incorrectly, then the subscriber organization needs to be responsible for them. So that, I suppose, might require some additional controls or regulations. So we need to think about that to make sure we understand it, because there's a lot of material in here. And but I think we've got the general idea. It hopefully is a quick fix, but we will want to spend a little bit of time mulling it over and making sure that we've touched base on everything.
Okay. That was a proposal here that you take this over a break period and come up with language that hopefully also satisfies the commissioners. Mr. Feinstein, did you anything else at this point? Otherwise, we'll go ahead and move on.
No, I'm grateful for everyone's consideration here and for working with us on this. We really appreciate it and look forward to hearing staff's feedback on this.
Thank you.
And Your Honor, just so folks know, when we go to break, staff will set a Google Meet up and send that out to the working group. So we'll just get back on live as soon as we're done here and take that break and see if we can work this out.
Okay. Let's keep moving then. Find out where we are here. Okay. So we've now touched all sections so we can holistically deal with this subscription coordinator. Is that correct, Ms. Best?
That is correct, Mr. Chairman. I believe we're now on to the brownfield clean fill site issue.
Very good. Okay, just moving down page 1, we start with a definition, and I guess the question I start with: do we need to have now a separate definition for municipal rubble? Municipal, what is it called? Municipal or rubble landfill, such that it's not under the brownfield definition. Because that was from yesterday's conversation, or Tuesday. That was a concern I know that MEA raised, and also was a concern raised by Commissioners O'Donnell and Linton, that we have a separate definition, and then we could discuss the economic benefits of this new defined landfill or refuse facility. So let me start there. Is that correct, Commissioners Linton and O'Donnell? We need a separate definition, and then we can move to the discussion on the economic benefits of such a designation.
Chairman, I think that's right. I think my concern, just speaking for myself, was that we not create under the definition of a brownfield something that may not actually be a brownfield, try to shoehorn it in there for the purposes of getting the benefits attached to brownfields. And if you want to do that separately, fine, but don't redefine brownfields so you can shoehorn it in, something in there that you're going to find beneficial for CSEGs. Because it would be inconsistent with the definition of brownfields throughout Maryland policy, I think.
Yes.
Possibly.
Commissioner Linton?
Sure, I agree. The better option here would be to create a separate definition and then figure out what solutions or benefits should fall under that definition.
Okay. All right, let me turn to Mr. Vanderheyden. I'm looking at your document now, and I think you have a definition.
Yes, Your Honor.
I want to reconcile this definition then with the CCSA definition. Can we have that conversation?
Sure. I think what we're trying to do here is we take the language that was proposed by CCSA that would have taken these. We're going to define clean fill site, and we're going to define it as a filling operation that basically doesn't require a permit, and the language explicitly says that they're exempt from the MDE COMAR 26 that requires permits. So it spells out an exemption there. Now, in sort of thinking ahead, that I know that what was explained to me yesterday, I think Ms. Uhas sent me the email. They would like to have these clean fill sites to have exactly the same benefits as a brownfield would. And so with that in mind, what we are suggesting is that we're effectively going to identify these sites, because we can't just accept any site that, I mean, presumably most sites are exempt. We need to have some documentation that it is in fact a clean fill site. So what we're looking for here, and I think this was based on a suggestion that Mr. Comas over at MEA had talked about a couple of weeks back, but in the event that you've got a clean fill site that is unstable and you can't build on it for a period that is going to cover the in this case 20 years should be enough. So for the next 20 years, which is going to be the most, the program's 25 years, but to the extent you have a site that is a clean fill site, it's not hazardous, We're going to define it as something that doesn't require a permit because it's exempt, but it is use is restricted by the local or municipal government. And of course, the problem we run into here is we need to have something that indicates that the building is restricted or that it can't be used for recreational or commercial or agricultural use because it's not safe. So I don't know if this is going to give us all of the documentation we need. It may end up that that the applicant for a site like this will have to go to the county zoning or the county department that would issue building permits and say, can you clarify for us that this site does in fact have restrictions on use if it's not something that's perhaps attached to the deed already, such that we know that this is in fact a site that you can't build on, you can't plant crops on it, it doesn't have other commercial uses, and it's not suitable for recreation. So if all those things are the case, then why not treat it like we treat brownfields? So what we're trying to do is saying, if you have a clean fill site, that is, you have some documentation from the local government that indicates it's not usable, that we're going to define it that way. And then I believe, now we didn't make these changes, but I believe Ms. Uhas is proposing.
Can I just stop you there? So I think I've got where you're going. Can you then just compare that language with what was proposed? I believe it was Ms. Uhas. She would simply state, it looks like the first sentence up to which, and then do you have that in front of you?
Yeah, I can see it.
So a subscriber organization or property owner has provided a sworn affidavit certifying the filling operation meets the exemption criteria under COMAR 26040704C5.
That's not the same thing as what we're suggesting, Your Honor. That appears to
Okay,
be
well,
that it
that's
doesn't
what I'd like
require.
to engage.
Yeah, I'm sorry.
What's your objection to this definition, just so I understand the position of staff, and then we can turn to Ms. Uhas.
Well, so 26040704 or 0704C5, that is the exemption that says you don't have hazardous material in it. So this would be a swearing or an affidavit that says this is not a site that requires a permit. But what we're asking for is, if we're going to treat these things with the same benefits that brownfields have, they should have they shouldn't be usable for anything else. The whole point of allowing brownfield use or to be co-located and to fit into the category for brownfields is that they reflect sites that aren't otherwise usable for anything else.
Well, I mean, let me push back a little bit on the anything else, though. I mean, there are other things that can be done on brownfields. I mean, I don't, other than a solar development, and so I just want to understand in this circumstance where a local government has worked with a developer and then they have said, yes, this Rebel site, this is a good economic use for this site. Why would we at the Public Service Commission, since we don't have siting authority or permitting authority in these cases of 2 megawatt or less, need to get involved in that situation? I mean, if the local developer has worked with their county and they've identified a site that they agree this is the best economic use, why go to the, I would almost extreme of saying it can't be used for anything else? Then and only then can we use it as a solar development.
It's a very good point. The law doesn't permit us to build on contiguous sites. It just flat out says you can't build on contiguous sites unless it's on a rooftop. Now we allowed brownfields to sort of squeeze in there. And in this case, we don't have the legal authority to grant co-location for anything unless it's on a rooftop per the law. So this is merely a way for us to equate it to the existing sort of, I guess, little alteration in the way one might interpret the rule or the law itself. So this would allow co-location, and effectively, if you're building more than one site on a property or more than one project, you're effectively exceeding the 2 megawatt cap that's in the legislation. And if you would be building on contiguous property, you'd be violating the rule or the law that requires it not to be built on contiguous property. So
Well, we've
I'm just
made
trying
a
to,
exception for brownfields on our own. Okay, let me stop there. Let me go ahead, if it's okay, commissioners, to allow Ms. Uhas to talk about her language. And then, since this is an issue of particular importance to Commissioners O'Donnell and Linton, I'll let you chime in at that point, if that's okay. Ms. Uhas?
Good morning, and thank you, Your Honor. Yes, we propose this language to, we believe, succinctly bring to bear the definition that is already defined. The clean fill site is already defined in the COMAR section referenced there, the 26040704C5. So it is, again, very specific as to what material is in that, what is defined as clean fill. So yes, we would be defining a new category, not changing the definition of brownfield. So I think that's clarification number one, or confirmation of your understanding of number one. And then number two, having the landowner or the subscriber organization providing that affidavit that the filling operation meets that the exemption criteria also included in COMAR 26040704C5, that it brings both of those issues, to closure, in that confirming that the fill site does have what is allowed to be in a clean fill site, and number two, that it has been operated as such.
Yep, and Commissioner Richard, I would add one thing. This is Solar Naini to that, if I may. This is in response. The affidavit is in response and acknowledgement of the fact that local zoning, as we all know, local zoning is going to be a little bit different in how they view this specifically, and so by having that sworn affidavit, it helps kind of bridge the divide. And the concern that staff had earlier, which was, we were having a hard time coming up with what documentation we need in order to validate that it is indeed a clean fill site. And so this is helping bridge that by the SO or the property owner having that sworn affidavit.
Okay, thank you. All right, and of course, we haven't talked about the economic benefit that's to be attached yet to this definition, but let me turn to Commissioners O'Donnell and Linton on this topic.
So I'll just say this, that I think moving it out of the brownfields definition is goes a long way to assuaging my major concern, which is redefining brownfields. Maybe for purposes that wasn't intended for the definition of brownfields. And it's not clear in my mind, Mr. Chairman, whether or not the COMAR 20.62.02.01B restriction is necessary, that it can't be used for anything else. I'm not sure I'm finding that. I mean, we want to find a way to allow a developer to locate CSEGs on a clean fill site. That's really what we're trying to do in my mind. And how we do that without getting too restrictive is the key to this, I think. So long story short, it's not clear which definition is going to accomplish that appropriately. Commissioner Linton?
Commissioner O'Donnell, I actually had a question about the CCSA proposed language regarding the provision of a sworn affidavit. And maybe this is not necessarily just for CCSA, but is it appropriate to say that the local government would also know this information? I mean, the way I'm correct me if I'm wrong, but at the time that the subscriber organization or property owner is attempting to go forward with this transaction, the property will either meet the exemption criteria or it won't. So I'm just curious if the local government would know this at that time.
If the local government would know that,
That the exemption is met. The exemption criteria under 26040704C5.
I would believe they would, because they would know the type of fill that is in that facility. It would most likely have to be disclosed during the permitting during the stormwater and erosion and sediment control process, approval process.
Right, okay. So I've been reading the two of them to see if the language could be combined in some way, and it's because I think they're saying similar things, but take me a minute to try and think it through. But I think for that particular point, the CCSA language is basically something that the subscriber organization, and I suppose even the property owner, could verify as part of the application process, or that's or the process that the organization goes through to proceed. This is something that they should be able to obtain from the local government.
Yes.
Okay, in which case, so now we're just looking at an extra document or extra form of verification that we actually are dealing with a clean fill site.
Correct.
So thank you, Ms. Yuha. So let me go back to Mr. Vanderhaden then. For these, if a property is exempt from, I'll just say 04C5, the clauses that you have listed here for which construction, agricultural, commercial use, or recreational use is restricted by a local or municipal government for a period in excess of 20 years. That period of time, if it's exempt, does that period of time exist all the time, or could it be for a less period of time, more period of time? How does that 20 years come into play?
Your Honor, the 20 years is assumed to be the time remaining before building can commence on a site that was determined to be unstable. So if a site is not, I don't think the language in 0704C5 does anything other than allow you to not require a waste disposal permit. I mean, the exemption that it's providing is an exemption. You don't need a waste disposal permit. It's not certifying anything other than there isn't hazardous material in this location. So once there isn't hazardous material in a location, that presumably would persist indefinitely. We're trying to reflect that the understanding that a clean fill site would not be something you could use for any other purpose, and because it's dangerous or unstable and hasn't settled yet. So the idea is if you have building restrictions on a site that you can't do anything with it during the course of the program, or 20 years in this case, it would be fine to treat it in the same way you treat a brownfield. So that there's two different distinctions there. One is this is not a site that requires a permit, and that's what CCSA has provided. We're suggesting that there would be another distinction is you have a site that cannot be built upon because of local restrictions due to the fact that it is a place where clean fill has been piled up or filled in.
So can you tell me what the genesis is of the 20 years? Is that in regulation somewhere, or is that
so
statute purpose?
20 years is a figure that reflects that the program will be in effect for 25 years, which is, I believe, in the regulations, if not the legislation itself. So once a project is constructed, it is permitted to receive credits and operate under the utilities tariff for a period of 25 years after, in this case, 2024. So if you have a site that cannot be built upon within 20 years, which is more or less, we could have said 25, but I think 20 years was assumed to be sufficiently long enough, such that you have a site that's not usable for another purpose, much in the same way a landfill isn't usable for another purpose. During the 20 years is just reflecting that it would be consistent with the same time the program would be operating. So if you have a site that cannot be used for other purposes during the course of the program, then you can treat it in the same manner you would treat a brownfield, which presumably isn't usable during the course of the program or for many years after that.
So can a clean fill site, and this isn't just for Mr. Rennie, certainly anybody can answer, but can a clean fill site, once a local government acknowledges and makes it clear that it is a clean fill site, could it be, I understand that somebody could try and do something to it to make it into a different type of site or location. Does that typically happen, or are we talking about a situation where once a local government determines that it's clean fill site, it's a clean fill site, and it doesn't suddenly become something else at a point in the future?
I'll take a crack at that. We don't have any understanding that there are permits for clean fill sites. There are no waste disposal permits required for a clean fill site. So there may be a building restriction such that if you apply to get a building permit at that site, it would be noted that the site, doesn't pass its whatever stability requirements. But it was suggested to us, I believe, by the folks from MEA, that we could identify these sites as qualifying if there was some documentation where building was restricted or the property was otherwise encumbered. And it was suggested that might show up as something that's on a deed or potentially something that came from a permitting authority at the local government.
Commissioner Linton, if I may try to attempt to answer your question, I think it really depends. It's a little nuanced in the fact that it depends on ultimately what type of waste is in the clean fill itself, how that waste settles, what sort of load-wearing weight you would attempt to put on it after the fact. In our experience, sometimes you may find clean fill sites where it's very challenging to do anything else because there was a lot of different types of debris that were placed under it. You have everything from steel to concrete and different types of materials, all uneven throughout. So in some cases, it may be more challenging to put anything to do anything else to it at a later date, which is one of the big reasons why these sites are actually desirable to place solar projects on them.
So, and if I may, this is Francis, to add to that, in all due respect, basically this language as it is written, the language in green, I don't believe that you would actually have a county to be able to rule that say it can't be used for anything else. That's not their business. Their business is to provide approvals and permits for which the criteria has been met for a specific site that an applicant has applied for approval for the proper permits. So essentially this language would deem this just not usable, just not workable. No sites, I think, would move forward. And that would be an unfortunate situation given the opportunity to use less desirable sites for the purposes of solar. And getting back to the time limit, these community solar projects are temporary. They're not permanent. So at the conclusion of the 25-year program, at that time would be another decision point for what could be used that property could be used for.
All right, thank you, Mr. Uhas and Mr. Naini and Mr. Vanderhayden. I appreciate it. So, Mr. Chairman, I think it's the question of trying to figure out how long the property could be defined as a clean fill site beyond the date at which it's presented to the commission. I think that was the concern I had regarding the green language. And the question of relying on a subscriber organization or property owner for providing the affidavit when the local government would have the information and would be ultimately the one that would know anyway, is a concern I have with the red language. So I think that, I mean, I guess it depends on which one we like better, but I'm leaning more towards the red language, but I'm leaning less towards the idea of having a subscriber organization or property owner sworn affidavit in lieu of some type of documentation that could be, even if it's just a letter, I suppose, or something that confirms from the local government, especially when the subscriber organization is interacting with them anyway, for permits and things of that sort, that this is a property that meets the exemption criteria. I haven't heard anybody suggest that a local government can't produce that information because they already know that this is what we're talking about as a clean fill site, or at least they'll know what type of site it is, and they could provide that information for review. So with that kind of edit, I would be more in support of the red language. I'm not opposed to the idea of making sure that the clean fill site remains a clean fill site, but I haven't heard it said that we know how to do that. So
Okay.
I'm tending to.
That's also where I am. I'm sorry, Commissioner Linton, or I'm Commissioner O'Donnell.
Commissioner Linton and I are often confused for each other, Mr. Chairman.
I was about to speak. I just wanted to recognize you. That's all. Sorry.
So I think I'm similarly inclined to the red language, but in my mind, the only way a subscriber organization or property owner could ever sign such a sworn affidavit would be by certifying it through the local government entity that has the information. I mean, people don't intrinsically have this information. They have to have an authority that information resides with, and that would be the local government. So I think Commissioner Linton is right. You know, how would a subscriber organization or property owner sign a sworn affidavit unless they've verified the operation meets the criteria of COMAR 26040704C5 with the local government? They would have to. I don't know where else you would pull that information from.
And again, I got started here with that presumption that they were going to provide a sworn affidavit that they had, certified, or they had verified with their local government that it met this, this definition. So if that's not clear, as I presumed, maybe this is here we can just verify. I mean, or just clarify that this sworn affidavit certifying that it is through their local government that it does meet the requirements for this clean fill site. I think that's what we're all saying. Is that correct? We just need to, it can't be just anybody signing this document. They have to have verified that through a source with the local government.
I think Commissioner Linton might be suggesting that the certification come from the local government, not the subscriber organization. If I'm hearing that wrong,
yeah, that's.
I thought they had to provide the application, and in the application they had to have all these documents. So again, that was just my presumption. But how do we tighten this up so that this satisfies Commissioners Linton and O'Donnell that this certification is coming from the local government authority?
I believe it. I believe that we can work with that, and it would be the county providing a letter to that effect.
I think that's fine. That's, and this Commissioner O'Donnell was correct. I was proposing that it come from the local government. We don't want the property owner to say, "Oh yeah, this is a clean fill site. Give me the check," and then he's in Florida and we're finding out later there's a problem. So we need to make sure that the local government is the one that confirms that this is a clean fill site.
Okay.
Commissioner,
Affidavit should so certify. I hear a voice.
yes, Commissioner Richard, I was just going to make some suggestion to the language in red if we wanted to tweak it real time. So for which a subscriber organization, and then we would strike out or property owner has provided evidence from a local land use jurisdiction or local authority having jurisdiction, I suppose is more appropriate there.
Okay.
Jurisdiction. Certifying the filling operation meets the criteria. Or maybe just that the filling operation rather than certifying. Replace certifying with that.
Yeah, that sounds to me like you're going in the right direction. So rather than maybe doing this on the fly, I think, I'll go back to Commissioners O'Donnell and Linton. You've heard our intent, what we'd like to see. If you can just work on the language and make sure that language and you and staff are together on the language, I think then we have made this decision. But if you can maybe, rather than trying to do this here on the fly, that'll be something else to do during a break or the lunch break. Because it sounds like all three of us are in favor of the red language. Can I ask then what the intent is for the economic advantage? I'll just say from the beginning, mine is that it have the same advantages, the same economic advantages as a brownfield. So that's my position. I'll turn to Commissioners O'Donnell and Linton to find out if that's their position or if they were thinking of some other economic advantage to this definition.
I was not, Mr. Chairman. My intent was not to stifle C6 development on cleanfield sites at all. And to the extent that they can be economically incentivized to locate there, the same attributes that attach to a brownfield could attach to these. In my mind, they're just not defined as brownfield. So that's kind of where I'm at. I'm similarly situated to your thinking.
Okay, good. Commissioner Linton.
I also agree, Mr. Chairman.
Okay. All right. So if we can work on language over the break that cleans up this language and then also provides the same economic benefit of the clean fill site as we provide to brownfield site, then I think we've decided this issue. All right. Well, it's 11:30. I think I owe everybody a break at this point. Why don't we make this just a 10-minute break so that we can come back and see if we can finish the issues, and then we can talk about what length of break we need for lunch so that we can hopefully have language we can wrap up with after lunch. So at this point, I have 11:35. Why don't we come back at 11:45? Okay, I have 11:45. Let's plan on getting this started back up in about 30 seconds. Doug, are you set to go?
I'm ready, Your Honor. Anytime you want.
Okay. Okay, we are back on the record, and we will continue. Let's see as we scroll down. One thing we did spend a lot of time on the Brown or on A. That's where I had additional language come in from CCSA, and I don't see any other language for B and C. Can I just ask parties, is it the intent that we also have these as standalone definitions? Probably more importantly, let me start with my fellow commissioners. Commissioner Linton and Commissioner O'Donnell. Was that the intent to have all three of these municipal rubble landfill regulated under a refuse disposal permit, and then C, mined land as defined?
I think that's right, Mr. Chairman, as long as it's consistent with previous definitions of brownfields.
Yes.
Yes, that was my intention, Mr. Chairman.
Okay, so if we could just, for Ms. Bess and for the parties working on the final regulations or proposed regulations over lunch, let's make sure those are no longer under the definition of brownfield, are standalone, and that it is our intent that they also qualify for treatment, for the same economic treatment as a brownfield. So again, I'll just pause to make sure I've stated that correctly from Commissioners O'Donnell and Linton. Good. Okay. Let's continue to scroll down. So we got. Okay. Where, Ms. Best, do we have? I think the next issue now are the start dates and the program dates.
You're correct, Mr. Chairman.
Okay. All right. I'm going to turn now to the staff proposed language, and it appears, okay, it does offer, I guess, the splitting, the bifurcating of the years as proposed by Commissioner Linton, are I guess accepted by Commissioner Linton. Is that correct, Commissioner?
Yes, that's correct.
Okay. But I'm not certain, well, the allotments, I think that's where we still may have some discussion with CCSA. So maybe on here, Mr. Van Hayden, if it's okay, let's start with CCSA, and they can react to your language, and then you can discuss what you're proposing. And I'm not sure who's taking this issue for CCSA.
Yep. Chairman Richard, this is Salar Naini. I'll handle this. As far as the language, I'm looking at the language on the screen. Are we referring to the language? The language on the screen looks like the old proposals from both CCSA as well as staff. I believe staff had sent out separate language at 4 p.m. yesterday.
Right. And I'm looking at that document now, and I do see again how they've divided years 5, 6, and they've changed the allotment in those years. I know that was part of what we were intending to try to accomplish, but I just wanted to turn to you to say, does this complete a CCSA? Is this a consensus proposal now?
Sure. I think I'm going to separate the issues. I'm going to look at what the language we have before us as it relates to the wait list. CCSA's intent on agreeing to sparse out the start dates. We did not have any intention of making any modifications to the wait list. It was our understanding and our view that that was an issue that had already been settled. So we would not be supportive of anything in number 2, but we would be supportive of what was already approved. Which again, I'll just remind everybody, in our view, it's already a practice that has been outlined pretty clearly, the waitlist process in the tariffs. Companies, both new entrants and existing entrants, are referencing that when they decide to make investments in this market. And CCSA did not have the wait list as part of our original filing. Staff had proposed it, but we thought came to consensus on it based on the fact that we thought it was essentially codifying what was already in the tariff and the practice. We just thought it was a good idea to include it in the regs as well. We agreed with staff in that sense. So long and short-winded way of saying, at least on the wait list specifically, we would not be supportive. We would be supportive of what the commission had voted on yesterday.
Okay. Yeah, that was my understanding too on the wait list issue. But as far as the annual caps, I just wanted to make sure as we move down the proposed regulations that what staff is proposing right now, it's not reflected on Ms. Best's document, the document that cleans up all the actions from Tuesday.
Right. You're referring to the percentages that we were wrestling with, this part.
That's correct. Right. And again, I'm looking specifically. Do you have before you staff's document with their revisions for today's discussion?
I do. So if we're specifically talking about number 2 with the different percentages, we are in agreement. What is currently on the screen, we are in agreement. I believe the document that staff had sent out had tried to separately parse it out between January and July, and we would not be supportive of that. And I think they tied that into the wait list, the separate wait list concept that they introduced. But what is on the screen in terms of the percentages, we are supportive of.
Okay. All right. Well, any questions at this point from Commissioner O'Donnell or Commissioner Linton? I did want to go to this wait list because, again, I thought this was something we had already discussed and decided. So anyway, let me turn to Commissioner O'Donnell and Linton on these annual caps, and then on this point about the wait list.
I think I had asked Ms. Garofalo to look at the legal sufficiency complying with the statute. She said, "You don't mean right now, do you?" And I said, "No, I mean right now."
Well, Your Honor, I did look at that last night. The annual capacity limits for each category under the law should increase annually for the duration of the pilot program. And the commission has handled that by having each of the 3 categories increase as a percentage. And so they do increase according to the commission's assignment of percentages. I couldn't understand and so I think that is met. The question yesterday was if they're handled in a certain way, that would mean by year 7 there'd be no capacity to allocate. And so Mr. Naini suggested, he said a 6-month capacity. That's why we submitted the language that we did. This becomes a little bit a matter of arithmetic after that. But Mr. Vanderheyden reviewed Mr. Naini's 6-month awarding of capacity, and that overcomes the aspect leading to an increase each year. Under this methodology, it's not really necessary to reach the question of whether capacity as a whole must increase each year. But certainly you're in compliance with the law, And by awarding them in 6 months increments, I couldn't understand whether Mr. Naimi said he was objecting to that or not, but he said they would, yesterday, he would not, they did not, CCSA did not object, and that allows capacity for each of the remaining years, but that's the reason for the January through July, and then July through December dates.
Right.
Thank you. Mr. Naini, what say you? Sounded like to me, yes, on Tuesday you agreed, and now I think I hear you objecting.
So yes, thank you for the question, Commissioner O'Donnell. We agree with the 6 months, and we can go through the specific section and how I guess CCSA has been thinking about it. I think staff had introduced a new concept into the waitlist section related to the 6 months, specifically carving out a portion of the capacity for new entrants. So my understanding of the edits in the waitlist section that relates to the 6 months would basically reserve capacity for the first 6 months of each year for new entrants. And then once new entrants had not applied and the utilities had that period of time had passed, then the capacity would then open up to other entrants. So from our perspective, that was a brand new concept. Again, we received this language at 4 o'clock yesterday that had not been vetted out, and for that specifically, we would reject the language. In our view, the minor tweak that would be necessary in order to codify what we described on the program start dates in the 6 months would be in the language related to program annual start dates, section C. So here, in our view, and again, just a reminder, everybody agrees on 1, 2, 3, and 4 is CCSA's language. And in number 4, rather than program year 6 starting within 12 months after beginning a program year, we would just change that to 18. Now, I know I said a lot, so let me explain what that would in fact do in terms of dates to get us all oriented. So program year 5, we're in program year 4 right now. Program year 5 is set to start in January of 22. What this language in section 4 and the update to this from 12 to 18 would do is it would start program year 6 months earlier than it currently would start, which would be in July of 22. And then from there, program year 7 would start in July of 23. So long story short, what we would be doing is, I think the original CCSA proposal was suggesting that we would start years 5 and 6 in January of 22, but this language now puts a gap of 6 months, which doesn't quite get us to where CCSA would like to go in terms of getting the program back on track. But as a compromise, we offered that position that we think at least we're still 6 months ahead of where we're only 6 months behind as opposed to a year behind.
Okay, so let me go back to the waitlist question. Why would CCSA be opposed to what appears to be staff's effort to introduce some competitive spirit, nature for new entrants to get into the program? And then if it's not exercised, there isn't that competition, the capacity would become available to those who may already have an advantage because they're already participating in the program. To me, that seems to make sense.
It's an excellent question, and I very much appreciate the question. And I just want to clarify that we want to see competition in the marketplace. That CCSA's position is always that. It allows for better product offerings for customers, which ultimately result in permanent programs. In this case, our view is that the wait list process, again, if you go read the utility tariffs, it makes it crystal clear that if you don't get, you are in the wait list for subsequent years if you didn't receive capacity. And this has been in place since earlier this year when those tariffs were approved. So whether you are a new entrant or an existing market entrant, you're taking a look at these, and you, Commissioner O'Donnell, I know you as better than anyone have had to sit through a lot of these hearing requests for extensions on operation deadlines. These take a long time to develop. And so if a new entrant is trying to enter the market, they're looking to make a multi-year investment. And so having that line of sight to be able to say, well, if there's not capacity in year 5, that at least I'll continue making the investment in my project and be in line for year 6. We're happy with that. So I guess my response would be that if the current wait list structure that again has already been the practice is actually the type of thing that will allow, excites new entrants to come in. If you try to change the rules sort of midstream, it doesn't send necessarily the best market signal to new entrants looking to come in that, hey, this is how the program rules will go if you're making a multi-year investment, but we may change the rules kind of midstream on you, and maybe if you don't get in year 5, well, guess what? Now you're going to be in a second tier of applicants for year 6, which is effectively what this language does.
Thank you. That's very helpful for me, because it appeared to be maybe wrongly in my mind, but it appeared on the surface at least to be a crass attempt to protect the incumbents. And so I do understand better now after you explain the delays in permitting and the harsh, cold, frozen tundra of Maryland in the wintertime, which I don't buy at all. But anyway, that's a different story for a different day. Okay, thank you. That's helpful.
Commissioner Linton, do you have any questions at this point before we make? I guess we have two things. For one, we ultimately have to decide between the blue or the green language in this section. And again, I believe that by dividing the years, that does help come up with hopefully a more acceptable situation for you as far as reserving capacity year to year. But let me turn to you now and see if we're ready to make a decision between the staff proposal or the blue proposal, which would also, of course, take in the new mid-year allotments. So, Commissioner Linton.
Thank you, Mr. Chairman. So just to be clear, I see that the blue language has been changed to make program year 6 within 18 months. That's the proposal now as opposed to what it was before?
Correct, Commissioner Linton.
All right. Yeah, I don't have any other questions then, Mr. Chairman.
Could I ask a question about that? Does that mean that year 7 will begin within 18 months of year 6?
Mr. Vanderhayden, no. So that would all the other program years would start within 12 months, with the exception of year 6. So program year 7 would start in July of 2023, 12 months after year 6.
So presumably then there will be no capacity in year 7, and thus we wouldn't be in compliance with the legislative law, a requirement to increase each year.
That is not accurate, Mr. Vanderhayden. Again, when capacity becomes available, that is when projects secure capacity. As you well know, these projects are taking 3 years to construct. So there's going to be plenty of projects that have obtained capacity that may hit commercial operation in 24. They may even go out as far as they may even go as far as 2026.
Yeah, but what about the statutory requirement to have an incremental increase in each year of the program in capacity?
Great question. So it is the program years, if you will, have the incremental capacity is still assigned to the program years. But as we've discussed earlier, a year hasn't always been a year. In some cases, in most cases, a year has been as much as a year and a half, approximately. So it is our belief that if what this essentially would do is it would shrink program year 6 to become available within 6 months. But it is our belief that the years that it doesn't mess with the statutory intent because of that, because at the end of the day, it is these haven't followed calendar years. They've really kind of gone by what ultimately, between the approvals of both the regs and tariffs, how those years have actually played out.
That's why I asked Garofalo the question I asked her to look into for legal sufficiency, because deciphering nuanced legislative intent is a dangerous proposition. Trust me, it is.
And Commissioner O'Donnell, I might add, I know a number of the legislators had submitted a letter, I believe, as early as yesterday on this.
I'm sorry, that's not dispositive of legislative intent. and the Maryland Court of Appeals will be the first one to tell you that.
Fair enough.
So
Commissioner Linton, oh, I'm sorry. Go ahead, Ms. Garofalo.
So, Your Honor, last night when Mr. Vanderheyden calculated whether or not the commission would be in compliance by doing taking Mr. Naini's suggestion, we did this by 6-month increments. We didn't do 18 months followed by 16 months, maybe followed by 0. And I think it becomes very, while it's a question of law, the facts inform it, and the facts in this case are basically the arithmetic that go along with taking the commission's decision to increase the overall capacity annually, and then allocating that instead of by each year, but each year having 2 6-month periods. And I'm just concerned that if we take this 18 months, that we're still going to have a blank period with no assignment of capacity. Obviously, no one in this room, even the community solar developers, can assure that the amount of capacity allocated will be given to it will be used up as proposed by regulation, but that is certainly the most that we can do. And if we start talking about 18 months, my concern is we wouldn't meet our target.
There's still no capacity being released in the 7th year, which is 2024. So this staff's numbers, whether or not you will assign any capacity to new entrants to allow folks who are being attracted to actually participate, if that's left out, you still should follow the schedule that we propose, which is 0.8, 0.9, and 0.95. Then you are increasing the capacity each year, but you would not, in any of the years, in year 6, you wouldn't have given a 0.8 out. So you're giving more than you would have given out, but you're spacing it out over time, which I thought was what Mr. Naini was trying to achieve. What he's proposing here is simply going back to what we had yesterday, which doesn't give any capacity in year 7. So, I mean, you still have to solve that problem.
And Mr. Chairman, if that's true, that's problematic for me, because I clearly want to meet the legislative intent. And there's some question about that. Mr. Naini has one opinion, but a letter signed by some legislators doesn't make that true necessarily. And I think the statute clearly says you need an incremental increase in capacity each year of the program.
Thank you, Commissioner O'Donnell.
Excuse me. Commissioner Richard, this is Harry
yes.
Warren. Could I just offer some dates and facts and figures to support your analysis?
Certainly.
You know, I hope this is helpful. I think one of the difficulties about the statute that was written to extend the pilot program is that there's a little bit of a confusion between the 7-year pilot, which is described in the legislation, and the confusion about the no later than December of 2024 date, which is actually, if you count, is kind of a bonus year. And here's what I mean by that. According to the statute, the original statute for the community solar law, the program started 6 months after the regulations were finally adopted, the original regulations. The original regulations were finally adopted in July of 2016, which means the program started per the law in January of 2017. So if you count from January of 2017 and you count 7 full years, that 7-year period actually ends January of 2024. That's 7 years after January of 2017. Although the legislature kind of threw in this notion of a bonus year, and they said, but in no case will we let it end before December of 24, which is kind of an additional 11 months. And I think, therefore, what the industry has been trying to identify and sort of catch up on is that when really we just released in January year 4 capacity, but actually this is 5 years into the program. We're sort of a full year behind in terms of capacity awards versus legislative program years. We're 5 years into the program. We've just released what we're calling year 4 capacity. And I think that is part of what Mr. Naimi has been trying to kind of clarify, is that the notion of program years per the legislation that began January of 2017, we've gotten a little out of phase with capacity releases. So the proposal that CCSA made, as I see it, is just to finish up these last 3 capacity releases to actually assure that we get all that capacity awarded within the 7-year window of the pilot. And so the last release of capacity under CCSA's newest proposal would be July of 2023, which is within the 7-year window that actually ends January of 2024. So I think that's the notion of catching up. And so, Commissioner O'Donnell, at least, you know, to my reading, I would say that it sounds to me like you are within the right statutory framework. Capacity's been increasing. We have a 7-year pilot. The thing that I think has created a little bit of confusion, you know, maybe for all of us, is when the legislature put in that but not to exceed date, which kind of kicked it out another beyond 7 years, almost another full year. I think that that's kind of confusing the end date. So I don't think that releasing all the program capacity within the 7-year window, it doesn't seem to me that that would violate anything in the law that would say somehow we haven't made capacity available in year 7. 2023 will be year 7 if you count from the start. So I hope that those dates are helpful to frame up the discussion.
Ms. Garofalo, Mr. Vanderheyden, what do you have to say about Mr. Warren's assertions?
All right, I think I understand where he's coming from, and I think I mentioned yesterday that this really is a matter of defining when folks believe the program started. Another, element here is that the first applications came in 2017, and we started parsing out the capacity per the schedule on the date when we did that. At the time, that was determined to be the appropriate case. The entire working group with the utilities and the suppliers all agreed, and the commission approved the tariffs that began, issuing capacity. So if we have a situation where the program is still in operation, but there's no capacity available, which is what I think is in front of you right now, you will still have a problem in that you'll have a program year, whether or not, there's an explicit date that has been determined to be the actual start versus when the capacity was issued itself. But I think what we're trying to avoid is having a period of time when the program is still open, but no new capacity is being made available. So it's really, I suppose, it's a matter of how you would like to interpret the two different start dates that are observed, and how you want to make that comply. But I think from the practical standpoint, we think that what staff has proposed is consistent with the law and allows capacity to be granted over the remaining portion of the time the program is legislatively directed to operate. So this is really like, when do you want to start the program? And do you want to start it before the initial capacity was released, or do you want to start it when the capacity was released? I think those are the two interpretations that are in front of you.
Well, excuse me, if I could respond to that, commissioners, I actually think under the law, there's no room for interpretation on when the pilot started. The legislation says that the pilot started either 6 months after the regulations were adopted or when the first petition was submitted, whichever is earlier. That's what the law states. And so I don't think there's no equivocation about when the pilot started. As Mr. Vanderheyden pointed out, what happened in the early days of this pilot was, even though the regulations were established in July, the utility compliance filings did not take place until almost a year later, and therefore the first awarding of capacity lagged quite a bit behind the official legislated official beginning of the pilot. So I guess I'm all bringing this back just to your question, Commissioner O'Donnell. I don't see how. I realize your appropriate concern. Are we doing anything that violates the structure of the law? And what I'm suggesting is that there's no equivocation in the law as to when the pilot program started. And so awarding the capacity within the 7-year window that began in January of 2017, at least I know Ms. Garofalo is our lawyer on staff there, and she can certainly weigh in on this, but it seems to me that you're within the boundaries. And if Mr. Vanderheyden is suggesting that you would interpret that the pilot program didn't actually begin then, but you would want to interpret that the pilot program started when applications began to flow a year and a half later, at a later date. Well, I don't think that's I don't think that would line up with your concern about a legal interpretation, because the law is quite clear. So I think that if that's your concern, I think that the law is pretty clear on that, and you'd be within the four corners of the law, which is different than Mr. Vanderheyden saying, well, let's imagine the program started not on that date, but a year later, and then begin counting then. I don't know that would accomplish what you're looking to accomplish. Thank you.
So, Your
I
Honor.
think I would. I'm sorry, go ahead, Ms.
That by Mr. Warren's own calculation, the program would end in January, and that would be completely consistent with what the way in which you propose to present allocation and make an allocation of additional capacity available. So I think yesterday we wanted to avoid a year with the zero capacity being awarded. We spent some time trying to make that a reality, which Mr. Naimi helped us with during the rulemaking yesterday. And we would urge you to adopt the 6 month and 6 month, thereby avoiding an empty year.
Commissioner O'Donnell, any further questions before I turn to Commissioner Linton?
No, I think I'm thoroughly. I'm sorry.
Okay. Hey, Commissioner Linton, do you have any further questions on this issue?
Thank you, Mr. Chairman. I don't at this point.
Okay.
I don't have any additional questions.
Okay. Well, I continue to support the CCSA option. I guess it's the blue language. And you know, I really appreciate you know, trying to ascertain how we can be most faithful to the statute. It just seems to me that there's a lot of debate as to start dates and the fact that there was really a lag in how this program got started. So, and I also find that there would be a real benefit to having as many projects as possible completed by the end of this this period, at the end of by the end of 2024, and so I think really trying to move as quickly as we can to get this program back on track and get projects completed by the end of this extended pilot date. I just think there's value there, and I just honestly don't see where the harm is. I mean, there have been plenty of companies over this 5, 6, 7 years that know about Maryland's program. They've had an opportunity to participate, and you know, just given some of the trials and tribulations that the companies that have made this major investment in coming to Maryland and going through our process, and in some cases being in wait lists, and that I think that there is some real value in moving forward, and I don't think there will be any harm to you know, this company out there that, you know, I don't know it exists, that somehow will be left out by not trying to get this program back on date. So anyway, I'll shut up. That I do support the CCSA proposal, and I will turn to you, Commissioner O'Donnell.
Thank you, Mr. Chairman. Obviously, some strong arguments on both sides of this issue. And I think everybody's trying to do the right thing as they discern it and in accordance with the law. I am somewhat persuaded by Mr. Warren's explanation as to the start date of the pilot, either being 6 months after the adoption of the initial regulations or when the first application is received, whichever is earliest. And we have fallen behind. This is an attempt to get us back on track somewhat. And it's a close call for me, but I think I agree with you, Mr. Chairman, at this point, after all this discussion.
Thank you, Commissioner. Commissioner Linton?
Yes, thank you, Mr. Chairman. I also agree with the CCSA language.
Very good. Okay, Ms. Best, do you have what we need? I think this is something we've decided, correct? And we don't need to send to a lunch work period. Is that correct?
That is correct.
Okay. All right, well, let's continue to scroll down. Are we to the LMI co-location waiver, or is there anything in between that we need to verify? If I can, there we go. Okay. Oh, I just want to make sure too, we've agreed that we've already decided wait lists, so we don't need to, I don't want Commissioner O'Donnell Linton to speed past anything that you may want to discuss.
No, Mr. Nayini's explanation was helpful to me. So
Okay, so
I tend to agree with his assertion.
Mr. Chairman, there was, I'm sorry, I didn't realize that the wait list, the wait list provisions had already been decided. In terms of number 2, the capacity reservations, has that language been discussed yet?
Ms. Best, can you help from your notes refresh our memories? I can't answer that question right off the top of my head.
Sure. So the wait list, actually, the language that was reviewed on Tuesday was voted on by the commission and approved. What's here on the screen was additional language that came in yesterday And I can defer to staff on this, but I think this was really tying back to the discussion that we just had under the previous section for program start dates. So it is my understanding that I will remove the new language and put back in the language that was approved on Tuesday, unless, I mean, someone can correct me, but I think that's what I was going to do based on the conversation today.
Thank you, Ms. Best. Mr. Seegers, did you have anything that you wanted to go back on this language? Because this does appear to be new issues that we partially already well, the wait list we discussed on Tuesday, and these are I believe are new staff proposals.
If the language is going to go back to what the commission approved on Tuesday, then the Exxon utilities do not have a concern. As you noted, staff did circulate some new language, which is the language under number 2, the capacity reservations, and we did have a concern about little 2. But if that language is not going to be adopted, then we have no concerns, Your Honor.
Okay, yeah. Ms. Best, just could you confirm? But it's my understanding we are not taking this up again. Capacity reservations. We've decided the whole wait list issue. Just could you just reaffirm that?
Yes, Mr. Chairman, correct. I'm going to, I will, when we are finished today, I will take this out and put back in the language from Tuesday that was already approved.
Okay. And what the intent this afternoon to hopefully we'll work through getting some of these fixes on the language that we've discussed this morning over the lunch break, and then Ms. Best will provide, I guess, well, we'll provide the whole proposed regulations. Give you everyone a few minutes to review those, and then we'll go to vote on the proposed regulations. So I will provide some time, a short amount of time, but some time just to review everything that we have done over the last 2 days to make sure all parties agree that everything is correctly noted on the proposed regulations that we are drafting at this proceeding. So, okay. So, Ms. Best, help me. I'm trying to follow on my own larger screen here, so I don't have to squint quite so much. Where are we? Are we at the LMI waiver proposal?
I have one note under electric company credit allocation reporting. As of Tuesday, numbers 1 and 2 were approved, but I believe there was still a question as to whether section 3 was going to be added in terms, this is regarding the billing issue disputes.
Okay.
I think maybe a commissioner or 2 wanted more time to think about it, but like I said, 1 and 2 were approved. It's really just the blue language regarding billing issues, if anything further was going to be done with that, or if this language was going to be included.
Okay, could you help me? Which page is that on? Just so I can follow along.
So we are, I believe, on page 11.
Page 11. Okay, thank you. I've got my other much larger screen here to my left that I go back up to that. So page 11. How that slipped by us, huh?
Actually, Mr. Chairman, it was my recollection that I do recall that we did discuss this language, and it was my recollection that it was not adopted.
Okay. Help me out, Ms. Best. And actually, why don't I just go right to Commissioner Linton? Commissioner Linton, did you have a question that you thought you might want to think about? Maybe that's what I'm remembering.
I did have, Mr. Chairman, I did have some questions about this section, but
okay.
I think Mr. Seegers is correct that the conclusion was that we were not adopting section or the blue section.
Okay.
I recall similarly we discussed the utility of such a requirement, but on a much broader application. That is to say, there's something here, but this may not be the time or the place to address it, but the commission may want to address it in a broader sense with regard to billing errors of large groups of customers.
Right,
Because
yeah.
I think there is a public interest there.
Yes.
Yeah, I know we all agreed there. I was just waiting. Anyway, thank Ms. Best for bringing that back to our attention. I did have some recollection that Commissioner Linton may have had some further thoughts on that. But if that's not the case, we can move on. Right. So we are now to the LMI proposal, which we discussed, and we agreed to entertain a waiver provision. So I guess, let's see, for that, we have the staff proposal, or I'll turn to the staff proposal. I think it includes Ms. Miller's proposal, and then it adds some additional elements. So they find that. Anyway, at this point, why don't I turn to Ms. Susan Miller? Do you want to discuss your proposal? For
Yes.
the waiver?
Sorry, Mr. Chairman Richard. Yes, thank you. Good afternoon. We would like to thank the commissioners for continuing this discussion. Essentially, it is somewhat unusual for the General Assembly to codify legislative intent in its enacted statutes. But in passing the community solar pilot legislation, the General Assembly did just that, expressly stating the finding that it was in the public interest to promote participation by LMI customers in the pilot. This is the purpose of the co-location waiver. You heard statements Tuesday regarding the financial and other difficulties with developing LMI projects and how many of the projects in operation today, and our understanding is all only came into being because of grants, not because of market forces that enabled them to participate. The co-location waiver provision would improve the economies of scale and hopefully aid these projects in moving forward. Our proposed language was incredibly straightforward. It puts 100% of the burden on the solar developer when they file their waiver petition to file enough information to convince the commission that a waiver is warranted, and it gives the commission 100% discretion to simply say, no, we're not convinced, and to deny the waiver. We strenuously oppose the additional language proffered by staff because it directly undercuts and negates the purpose of this waiver. Staff's proposed additions create a burdensome process which will require the developer to devote significant financial resources to a project above the current cost of the project. Under number 2 proposed by staff, the solar developer would have to perform distribution grid studies, ecological impact studies, and ecological is not defined, and agricultural land studies, all of which cost thousands and sometimes hundreds of thousands of dollars. This burden is placed only on these 100% LMI projects and not on other projects. Staff is essentially trying to make this a mini CPCN process, which is unnecessary. Importantly, most counties subject community solar projects to lengthy technical reviews and permitting processes. This waiver would not in any way affect the authority of the county governments. The county governments could say, no, we don't want 2 projects next to each other, regardless of what they're for. The county governments could say, no, we don't want 2 projects on this land. The county governments can put any conditions on the projects. The county governments have been very assertive about how their zoning restrictions and where they want these projects and how they want them done. As a matter of fact, I live in Anne Arundel County, and sadly, from my perspective, Anne Arundel County, when this community solar project program first started, put a moratorium and allowed no community solar projects in the county. So the counties are the ones who are responsible for this, and the counties are essentially doing an aggressive job of where they want these projects and where they don't want these projects. So this mini CPCN project process that created by staff is simply unnecessary and would simply create more costs for projects that the purpose of this co-location exemption is to help them with their costs. And now to look at number 3, which staff has inserted language that limits the commission's discretion. First, I'd like to focus on 3I, which provides additional construction, development, and operational savings from the co-location result in corresponding decreases in subscriber rates. To me, that's a fundamental misunderstanding of why this needs to be done. Essentially, LMI projects want to offer a specific discount to their subscribers. Ms. Heller mentioned yesterday there's many projects that offer a 20 to 25% discount rate. But with regard to the 100% LMI projects and the interconnection costs of where this project would be, that the interconnection costs and other permitting costs are too high to be able to offer that discount. So the purpose of the co-location is to ensure that the discount that other LMI projects are receiving can be received by this proposed project. If you have to offer an additional discount on top of that because you are allowed to co-locate, these projects simply won't be built. The other two aspects of the discretion limitation, and one is a negative impact to ratepayers. We strenuously object to this because you should not have a project by project determination of ratepayer impact. We asserted at the beginning of this rulemaking session that we totally agree that a benefits and cost determination for the entire program should be analyzed so that it can be determined what the benefits and what the costs are. If you take one project, may actually have a negative impact, but if you take all the projects in its service territory, that may actually have a total beneficial impact for the ratepayers. So to narrow in on one project and put the whole burden on them as to whether ratepayers have a negative impact or not is simply unfair and not justified. The other provision is the negative impacts on agricultural land use or sensitive ecological areas. Once again, this is covered by the local government. They're doing their job. They're doing zoning. They're looking at these. They have permitting processes. They have technical reviews. It's their determination with regard to where they want these in their county. And the commission doesn't need to be involved in that determination. And finally, I need to say that to me, adopting the regulation as proposed by staff sends the wrong signal to LMI developers. Essentially, I happen to believe that this commission has been very supportive of LMI and LMI projects and has made tremendous efforts to try to encourage them. But looking at this proposed regulation, what it would do to me is discourage LMI projects because it looks like they're not wanted because of the burden placed on them to obtain this waiver. And I am personally of the opinion that if the language adopted by staff, proposed by staff is adopted by the commission, there will never be a waiver request for LMI co-location because no project will want to undergo these costs and still not be able to get a waiver and not be able to do the project. And Mr. Chairman, if you don't mind, I would like to ask Ms. Heller if she thinks I left anything out before we go to staff.
Thank you, Ms. Miller. Ms. Heller?
Thank you, Mr. Chairman, and thank you, Ms. Miller. I do not have anything. I think you covered it.
Thank you. Well, let me turn to our staff now to explain their proposal. But let me start. I tend to agree with Ms. Miller. This does seem like we're trying to create a mini CPCN process and really step on the siting and permitting authority for these 2 megawatt plant facilities, stepping on the counties. I think the intent is to really kind of allow the counties and the developers to work together and try to come up with solutions and as far as siting these facilities and given what the legislature has stated about the priority, the public interest in LMI, I am also having a hard time understanding why adding all these new requirements to what should be just, I think, a simple waiver process to allow the commission to decide seems rather cumbersome. But you can respond to my comments and go ahead and explain why you've added all this additional language to this, I think should have been a simple waiver process.
Your Honor, I'll respond for staff on that. So I think we looked at this, that it is not anything other than a means by which we could allow a project to co-locate two projects next to each other, which, you know, is not permitted by the statute, but we've allowed for to make use of brownfields and that sort of thing. So I think there was a presumption here that the reason we were doing this was that there was an opportunity to provide savings to the LMI subscribers. And so it might be helpful to understand that. Generally, the elements in 2 are to sort of guide an application to understand what sort of information would be provided in the petition. I'm not sure how the commission would expect to be able to rule on a waiver, but here I thought perhaps being able to define how the LMI customers would receive savings or the level of savings that are at least expected would be helpful. To the extent that by co-locating 4 megawatts at a location, if that didn't, you know, do something like close a circuit because it used up the majority of the capacity available, that would be, I think, helpful information to know, because there might be a perfectly good location for a 2 megawatt plant, but maybe the 4 megawatts creates additional impacts so that like other folks couldn't net meter on that location. And that's, I think, something that we understand or learned from the interconnection study that would have to be obtained anyway. Previously in the working group, there were 2 organizations that were concerned about both ecological impacts and agricultural land impacts. So the use of farmland or agricultural land, and then the installation of these projects in areas that could have an ecological impact, some of which is affected by zoning, and some I think we determined from our discussions is actually, you know, would not be. So the way this is described here, I think what we're just trying to capture is if we're going to allow co-location, and again, you know, we're talking about something that could be about 20 acres of property or more, we would probably want to make sure that by granting, you know, this could be built anywhere. This could be built on a brownfield, it could be built on a landfill, but it could also be built in a cornfield somewhere, and or in an area that, you know, was near a wetland or had other issues. So we spent a lot of time trying to reach a way to get to a way to sort of limit the impacts for what we were going to describe as supplemental capacity, and we didn't get to that. But 2 is just asking that information be provided with an application for the waiver, because otherwise I'm not sure how you would make that waiver determination without certain types of. There may be other things that are necessary, but these would just be some things that would be filed, and I can understand if there's some concern that this gets to be too burdensome. So maybe we need to have a little bit of a discussion as to, you know, what maybe define these things a little bit further, so that we understand that impacts of distribution grid is just to make sure we're not, you know, closing a circuit as a result of the installation of this project. And then ecological and agricultural impacts would be simply providing the information which is readily available for a tax parcel in you know, from the databases that we understand are provided by the DNR. So that's for item 2. And for 3, I mean, certainly you could just leave it open as to what the discretion of the commission would be, but I thought that what we were talking about, and maybe I misunderstood from what was conveyed yesterday, it sounds like maybe what Ms. Miller is suggesting is that you can't build 100% LMI projects at all unless they're a lot cheaper than others. I don't know that that is our understanding, because there are several projects that have been constructed already that are able to offer a 25% discount, from what I understand, and serve all LMI customers. So, you know, if we're extending this economic benefit, I thought that there would be some guidance that could be helpful if someone's going to consider making an application, that they'd be able to show that there was a cost savings that factored in the reduction in the installation expense associated with co-location due to the economy of scale, and showed how that would then be reflective in discounted rates or improved discounted rates. I mean, if that's not the case, then that might be information that's helpful to understand as well. And then negative impacts to ratepayers, that's sort of a catch-all there, but to the extent that a project were granted capacity at a site and then it caused problems for the distribution that wasn't otherwise reflected in interconnection costs, I think it would be helpful to make sure that the project wasn't constructed at that location if it brought those negative impacts to ratepayers. In particular, there could be costs, but I think generally we're thinking about the fact that a lot of these may be constructed in areas that have limited import capacity. And then, if it's determined that there is an impact to a sensitive ecological area, or if this is simply using up, farmland, it might be helpful to sort of provide guidance for folks who are selecting these projects that they don't seek out the lowest cost property if it has some other negative impacts to ecology or to agricultural use of that land. So again, I think what we were trying to do is provide a little bit of guidance around the waiver process rather than just leave it completely open, because I think that would sometimes it's helpful if there is an exception. I mean, I think we're treating this as if it's an exception to the requirements to limit to 2 megawatts and to limit to building not on adjacent property, which is the waiver for the regulations that's being asked for here. So we thought that these were reasonable conditions that would help one determine whether or not the waiver is acceptable. And in particular, there might be sites that are cheap enough and that they allow a very effective or really low rate that really helps out LMI customers a lot. But if you find out that the savings to the customers perhaps don't outweigh some of the negative effects that could cause by co-locating at that site, that's part of how the commission could make that decision. So we're just trying to put some guidelines around it. It's not intended to make it impossible or restrict it, but it's also suggesting that you shouldn't just take any place in the state where you can obtain the 20 acres of property and co-locate there, because we've spent so much time addressing where it's appropriate to co-locate and where it's appropriate to build on rooftops or other types of locations. That's our explanation. We didn't have a chance to talk about this a lot because we were trying to do this on the fly yesterday, but that's where it came out.
Thank you, Mr. Van der Hayden, and I'll turn to my colleagues. But again, I first of all thank Commissioners Linton and O'Donnell. I'm glad we got. I understood the objections to just putting in regulations for co-location, and I respect that. But I also really appreciated that we left open the door for a waiver process. But again, I'm just really concerned that what you are proposing would just in fact scare people off and really defeat the purpose of trying to bring to the commission. And ultimately it would be the commissioners who would ask good questions. I trust that we would ask lots of good questions, but again, have the opportunity to entertain these types of LMI projects. This would be something that would come already after a developer and a county and local governments have all agreed on something. And I just would hate to see us throw impediments in the way to these types of projects, and considering those types of projects that may never come to us if we really impose these types of restrictions or guidance, as you put it. So with that, let me turn to Commissioner O'Donnell.
Thank you, Mr. Chairman, and thank you for acknowledging my concerns with kind of exempting public interest considerations for generating plants greater than 2 megawatts and the co-location issues here. And I appreciate staff's attempt to bound those somewhat. I don't buy the argument that these things could be located on wetlands. I think all of the regulations that exist in the state for development will still apply through the local planning and zoning processes. They won't be exempt from that. And, you're not going to put them up in the critical area, for instance. you're still going to have to comply with all of those regulations. And so that gives me some level of comfort. And this is a pilot, and I want to learn here. Maybe, as Commissioner Linton stated on Tuesday, maybe two's not the right answer, and this may gain us some valuable information. I think Ms. Miller is right in saying the legislature stated its intent with regard to saying that this LMI type of CSEG's development is in the public interest, or participation in renewable energy, clean energy is in the public interest. But I also have to acknowledge that the legislature also said when they put the limitations in on 2 megawatts, that was in the public interest, I believe. Or else would they have done it? So there are competing things here. I think we have some room to operate. I'm comfortable with where I was on Tuesday, which is we put a waiver, a simple waiver requirement in here that the commission can address all these other issues. And I don't want to make this a bureaucratic nightmare. And I also think staff will still have the ability to pursue some discovery when an application for a waiver is submitted. So I'm good with the position of Ms. Miller and would not support the addition of the staff language.
Thank you, Commissioner O'Donnell. Commissioner Linton.
Mr. Chairman, I agree with Commissioner O'Donnell, yourself as well. I don't think there's a need to add too much additional information here. For the language that CCA has proposed, I would recommend adding additional language here, though. Specifically, and I'm pointing at what I guess would be the darker green of the two. Assuming I'm.
Which document are you looking at now?
I'm looking at right at the screen in front of us.
Oh, okay. I'm sorry, looking at the staff document. Thank you.
I'm sorry, staff. Yeah, I'm sorry. I see. Okay, so but there's two proposed language here. I was under the impression that the number 2 there, where the cursor is sitting right at the end. Well, whoever proposed it, that's the one I'm talking about.
Okay.
That's staff's language.
That's staff's language. Okay.
Yeah, I'm sorry. It's
the
purple.
Green is staff.
Wait, there's 2 greens on here, so I was referencing the darker green.
One is
All greens are
highlighted.
staff.
One is highlighted. One is not, but they're both staff.
They're all staff. Okay.
Yeah, just going to my copy. Yeah, let's make sure we're all looking at the same document.
Yeah, let's do that first then. Yes.
Yeah, I have on my screen just the staff document, and it includes Ms. Miller's language, which is in red, and then staff adds a 2. I subscribe, and then it goes into a subscriber organization shall provide in a petition for the waiver. Okay, that's green on this chart. Yeah, so we would not be accepting the green language 2. We would then be accepting 3, and then we would again not be accepting all the green language, which is, it's funny because it's a different color on my other screen here, but.
Okay, that's helpful. And let me take a quick look again then.
Okay, is that consistent with your view, Commissioner Linton, to strike that language?
Yeah, that is consistent. And this section. That should work.
And Commissioner Linton, can I ask you a question? The other day, you made a comment about, maybe we shouldn't specify the size of the, again, they would still be discrete 2 megawatt facilities, but do you think it's important to continue to have this, I guess, limitation of 4 megawatts? Or
before you answer that, if you go above 4 megawatts, you're going to lose my support for this whole.
Okay, I'll stop there. I will stop there. So, All right, it sounds like we have accepted Ms. Miller's language for a waiver process for LMI co-located projects. So, Ms. Best, I believe.
I'm sorry, Mr. Chairman.
Please, Commissioner Linton.
I'm so supportive of the waiver request language. I'm trying to, I'm stumbling over it as I read it. And that's fine.
Okay, we can wait.
Discussion, grant the waiver request as circumstances warrant. Well, let me say it this way. Commission obviously can waive COMAR on request. It's always cleaner to have it stated somewhere that the commission can waive a section on request. Maybe we've said this in other areas of COMAR, so there might be another place where we can just lift that language and use the same language here. Because all we're saying is that the commission can waive this upon request or upon filing of a request by a party or something like that. I guess I'm stumbling over the request as circumstances warrant.
Commissioner Linton, I'm
yes.
sorry. May I make a suggestion? The generic language says for good cause shown. So if you would like to change as circumstances warrant to for good cause shown.
And I think that's kind of what I was looking for. I was looking for something along those lines. Yes, Ms. Miller. Thank you.
I'm good with that, Commissioner O'Donnell. Good. All right. Okay. Okay, so Ms. Best, I believe we have two sections that we will be asking staff and CCSA parties to discuss over a lunch break. Can I just inquire about how much time do you think, obviously I want you to have lunch as well, but do you think, would you need more than an hour? Let me just start there. Ms. Garofalo or Mr. Benedict?
Let me just make sure I understand. We're addressing the issue relative to the subscription coordinator.
Correct. Language to make clear, okay, that the subscription organization is ultimately responsible party, is the ultimate responsible party.
And you mentioned a second section. I'm trying to recall which of.
I think we were trying to. Maybe you can help me, Ms. Bass. Was it we were trying to clarify language related to the brownfield?
Correct, Mr. Chairman. I believe there's still a little bit of cleanup work to do with the clean fill site.
Oh, that's right. We have to try to bring those two together. Okay.
Or that, and then also the economic benefit. Make sure that that is clear. That as being treated, that they are being treated similarly to brownfields.
So to be clear on that one, these clean fill sites, once we've worked that definition, they will effectively, you could substitute them in for where brownfields receive a benefit, primarily in the co-location exemption, which is in going to be on, I think, page 22 of the document. I think that's where that is.
I'll make sure make sure that's correct with Commissioners O'Donnell and Linton. But yes, that there would be these three new categories that would not be defined as brownfield, but would qualify for the same economic benefit as brownfield.
So I think if we can pull up page 21, I think that's all we need to fix with that, because right there it says of a combined capacity. So it says projects that are constructed in the following locations are exempt from A, and A is what we just talked about with co-location. That says you can't build on a contiguous piece of property and you can't build more than one on a single parcel. There on B4 on the bottom of 21, I believe it would say of a combined capacity not exceeding 6 megawatts on brownfield locations. Once we've defined what a clean fill site is, would it be sufficient to add to simply on brownfield and clean fill locations?
Yeah, I mean, just basically it's what now under brownfield we have a definition for A, B, and C.
And then I believe they want to add that language to the category, which I think we'd have to go dig it up, but there is a category for small brownfield and other, and I think we would just need to add language to that category that indicated that for the purpose of receiving capacity, a clean fill site would be acceptable in that category as well as a brownfield site. So we would not be changing the definition of brownfield, but we would be essentially equating a clean fill site as defined by this subtitle as equal the way that the subtitle treats a brownfield. I think those are the two locations, unless somebody else knows.
Yeah, and municipal or rubble, and then the mined land. So all those three, originally they were, the idea was to define them as brownfields, but now we are defining them individually.
But Your Honor, mined lands is already in the that's already in. If you wanted
Okay.
us I think
Okay, I just wanted to ensure that that's what's happening.
I think
That's what the commissioners, what we discussed. So
So
I'm
these
just
three
making sure.
categories, A, B, and C, are already part of the brownfield definition.
Okay.
So no need to call them out separately. What we called out separately was the clean fill location, because it may or may not be a brownfield. And I will also note.
I'm reading.
I will also note that it's going to be very difficult to find a clean fill site big enough to accommodate 6 megawatts. I think it's not practical, but that's okay. I'm not concerned about that. That gives me actually some comfort.
Your Honor, I guess
Okay. Yeah.
the trick might be, does it
That.
have to be entirely a clean fill site? I'm sure that will come up if there may be a clean fill site where only a portion of it is clean fill, and then I guess you may be suggesting that the entirety of the acreage to be used for the project, so the inside the fence.
Well, you could ask yourself the same question for a brownfield site.
I think the parcel, once it's determined to have been a brownfield, becomes a brownfield, but that wouldn't be the same for.
No, I know, but in terms of co-locating on, Jason, does it have to be 100% brownfield, or does it have to be 100% clean fill? You could ask the same question of both. That's throwing a whole nother discussion in here.
Well, generally, the municipal landfills are of such size, and then the mining permit sites are very large as well. So we haven't run into that yet, but it is a good point.
Okay. Okay. Well, is it clear now? And I would also request if you work with the CCSA representatives, Mr. Naini or Mr. Feinstein, you've been most active today. Did you have representatives that could work with Mr. Vanderheyden and Ms. Garofalo to just for efficiency, so that when we look at the language this afternoon, it hopefully has already achieved some consensus between the two. And then, of course, I'd also ask that you share that with OPC and MEA.
Absolutely. It sounds like staff suggested they were going to send out a link for a Google Meet that we could just all hop on and bang out some language that way. That would be fine. It'd be myself and Miss Frances Uhas as well on the clean fill stuff.
This is James Feinstein. I'll be there as well. Looking forward to it.
Okay, good. Just for efficiency, it would be great when we come back that we can not have to again have to go through trying to draft language, but have language that the parties have all agreed to. So let me just pause a second. Commissioner O'Donnell, Commissioner Linton, do you have anything you'd like to say before we break for lunch?
No, I could use a break, probably like everybody else.
Yeah. Okay. Again, going back to my original question, is an hour enough time, or would you like more time? Asking Mr. Vanderheyden, Mr. Feinstein.
If it's acceptable, perhaps we may take us an hour to work through this if we're going to try to come back with a draft. I mean, it could take a lot less, but I think it will take. Typically, an hour was probably good, and then I don't plan on leaving the building, so I can get by with 15 minutes to kind of decompress if that's what we need to do. But I leave that to the other parties in the and they're going to participate. So are you good with an hour and 15?
Hour 15 works just fine.
Okay, why don't we plan to come
Everybody
back at
else?
2:30? 2:30?
2:30 would be great.
All right. We'll see everyone back here at 2:30.
And folks, I'll send that out. So we'll meet up in how about 15 minutes?
We're off
Sounds
the
good.
record.
Thank
All
you.
right. Yep.
All right, my clock says 2. Sorry. All right, my clock says 2:50. Why don't we begin in 3 seconds? All right, Doug, we are on the record. Welcome back to the continuation of Rulemaking 56 for Community Solar. Thank you all so much for your working over the lunch break. I'm happy to hear that a lot was accomplished. So now I will turn to Phil Vanderheyden. Mr. Vanderheyden, would you like to go ahead and start us off?
Yes, Your Honor. So I think we got to all of the issues, and I think we have, for the most part, a satisfactory resolution. Amanda should have the document we were working on with all the changes in it. I think she's pulling it up now. So we can just walk through that, and I believe, can address each of the individual items. Maybe we'll just start with the subscription coordinator. I think this one's kind of, it's a little bit, it's simple, but it's a little bit hard to make sure we've covered absolutely everything. So we spent a lot of time on this, but I think we've got something that's fairly close, and with the caveat that, you know, it's possible that in amongst all of that stuff in Chapter 5, there might be some slight interaction with one of the other definitions we might need to rethink. But for the most part, I think we've addressed it. So the point here was to make it very clear that the subscriber coordinator, if they are marketing on behalf of a subscriber organization, is effectively places all the responsibility on the subscriber organization for the contract, as if they are in fact an agent. So we kind of struggle a little bit with how we make sure that they sort of are treated as an agent, but they're not part of the agent definition. And then it was recognized that a subscriber coordinator, when they do marketing, they may need an agent. So we think we've addressed that as well. So I think that the change that we are addressing is actually, Amanda, if you can go down to page, hang on one second, it should be on page 23, I think is where it is in the document, somewhere around there. So all of the changes that we made over lunch should be in red. And if we had to delete any language, you will see that in strike through. So well, we can start here. Okay, this is and then we'll get to the rest of it. So this is the language that originally was defining how the application or the registration process would be done for the subscriber coordinators. And so in particular, we are retaining the language in A, and what the word is being changed from register to apply. And so that follows along with the previous language that basically said we will use the application process in the same manner as we do for the SO that is in, I think, up in one of the other chapters. So the language in B is being removed, and this language here is basically saying that the legislation, you know, had to contain the following. So rather than specify that, we're going to remove that, and we are going to use the existing application process and the requirements that are on that authorized form once that's updated to cover the subscription coordinator. And then Mr. Herson had concerns about C. He needed that language there, and I think everybody agreed that with it, that if the subscription coordinator is going to work on a particular, or it's going to essentially sell any of the projects that the CGS, the subscriber organization, has to be provided to the to the commission and ultimately to the utility for the purpose of notifying if any of which projects are being worked on. So that's being retained. In D, I think staff had a concern of sort of binding the commission to make the subscription information or the subscriber coordinator information available on the commission's website. And we do understand that MEA is planning to provide this information along with the project information on their site. So what was added is in red there, where it says that the information will be publicly available under the commission's website or other website approved by the commissions. And so that sort of still binds the commission to make the information available. But it does, it allows for it to be placed on another website if that's where it's being provided. And we're not calling out MEA particularly there, but they indicated to us that this language they believe would allow them to provide this information on their website if that was the commission's choice. And I am noticing we are still retaining, I don't think we meant to do that, the word registered in D there. So that should probably be changed to the commission shall make the list of subscription coordinators for which application has been made or something to that effect under the word registered, because we're no longer using that. So just, yeah, if we could port the word, or yeah, if that's the correct grammar, that's what we would need to do there. And then in E, so this is necessary because, of course, we have a few folks that are already providing this service, and we don't want them, once the regulations to go into effect, to not be in compliance. So they have 180 days to apply as a subscription coordinator after the effective date of the regulations. So we basically have updated this to make it, I think everyone is happy with the language that's in here, and for the most part, it covers everything that complies with the way that the subscription coordinator is going to operate.
Okay. And I invite, if there are any comments or concerns, please go ahead and speak up at any time.
Does C, D, and E get relettered to B?
Yes, Commissioner. We did not attempt to fix the formatting as we were editing. We just didn't have time.
Okay.
But yeah, we'll need to fix all that stuff up.
Okay.
All right.
Good so far.
So that's that section, and then let's move further down to chapter 5. So a couple more pages down here. I have it on page 23, but it might be. So see if I have this correct. I don't think we made the changes. If we made them, would be in red. We didn't make them there. I think they're a little further down in I think it's regulation 15 and then 16, and there needs to be a renumbering. And this gets to the crux of making the agents responsible, or making the subscriber organizations responsible. So I guess it didn't come back in the red the way we think. Maybe the red's showing up as orange here, or brown, if that, whatever that is. So
I'm seeing like a pink and an orange. Is that what we're looking at right now?
So you see how there's an of down in the bottom of the pink? That's the color that I think is going to reflect the changes we made. So here, I think much of this had already been changed during the previous session, or during the session right before lunch. So this language in 15 says the subscriber organizations responsible for the actions of its agents or subscription coordinators. So that is basically, it used to say, when it was under the original application from CCSA, it said subscriber organizations, or in this case, subscription coordinators responsible for the actions of its agents. So in order to make it clear that the SO is responsible for the actions of its agents or for the subscription coordinators, we removed the reference to the subscription coordinator from the beginning of that sentence. And so now this just is applying directly to subscriber organizations. So this language, we believe, makes them completely responsible for the actions of any agents they're using. So, folks who are selling subscriptions on their behalf, just by telemarketing, for example, and if there are subscription coordinators that are working for the subscriber organization. And then, A and B basically say, a subscriber organization may use an agent or a subscription coordinator to conduct marketing or sales. And then B, I think, is perhaps the meat of the requirement. The SO is responsible for any fraudulent, deceptive, or other unlawful marketing performed by its agent or subscription coordinator while marketing or selling subscriptions on behalf of the subscriber organization. So again, we think this covers it without, there's a lot of different places that we have to also make sure there's nothing else, but we think this does it for the most part. Let me just, if there's no questions on that, I will explain why I'd like to add the second.
Yeah, why don't you pause just 1 second and make sure, I want to make sure that Commissioner O'Donnell and Commissioner Linton have a chance to think about this and if you have any questions at this point, because I guess I thought that when we left this discussion, we were talking about the subscription organization being the ultimate responsible party. I'm reading this now that we are shifting that to the coordinator.
No, that is not the intent. I hope that's not how it reads.
The coordinator is responsible for the actions of its agents.
Oh, that's 16. I'll explain that in a second.
Okay.
But we thought we needed this to be clear because of once we removed subscription coordinator from the beginning of 15, we realized that if the subscription coordinator is not marketing on behalf of an SO, it still needs to be responsible for its own agents.
I see that. I was just I didn't make the connection between these two right away. I just saw it standalone. So I see what you're doing here. Commissioner Linton or Commissioner O'Donnell, do you have any issues at this point?
I'll wait till the description of number 16 because it's still not clear in my mind if the subscription coordinator is responsible for the actions of its agents, what liability does the subscriber organization have?
So I think we can explain that. We think this is a solution, but again, this is one of those places where it's a little bit unclear if everything is absolutely 100%. We think for the most part, but let me try to explain 16. And of course, there's a renumbering that will have to occur because there's already a 16. But so in the event that the subscription coordinator is using an agent on behalf of itself, there would not, and there wasn't, by removing the word subscription or the word subscription coordinator from 15 in the beginning of the sentence, it left the question as to, well, what happens if a subscriber or subscription coordinator has not established a relationship with a subscriber organization, but is sort of gathering customers to be ready to accept a subscription when they have established that a relationship with a subscriber organization. So we did not want there to be, in the event that, and the example that I think we used is if someone promises a subscriber that I will get you a community solar subscription in 2 months and it'll be, this price. And then they fail to do that because the subscriber organization that they were going to contract with either fell through or something didn't work out. And so then someone claims, hey, I signed a contract and I missed out on this other opportunity, and they didn't provide the subscription to me. Well, there's no subscriber organization involved because the contract was never signed. So in that case, the subscriber coordinator has to be responsible for its own actions because it's not marketing on behalf of a subscriber organization at that point. So we tried to, this might be a little bit, kind of going in loops here, but the language in 16 is basically to make sure that a subscription coordinator that is marketing on its own behalf without having yet an arrangement made with the subscriber organization is responsible if they use a sales agent or door-to-door or telemarketing or something of that nature. So that's what it's intended to do.
Yeah, can I just to pause here? So, for me, I want to make sure that this is this works for the business model and how this is functioning in other states. But I guess I am trying to understand this subscription coordinator who's acting without actually being affiliated with any subscriber, excuse me, any of the SOs. So maybe someone from CCSA could help me out with this.
Sure, Commissioner Richard. So it's my understanding that doing so would be in violation of COMAR, and in violation of the regulations. I'm not sure you can, market for a CSH project unless you have a relationship with the subscriber organization and, customers can sign up with them. So it's definitely our interpretation that we are okay with just keeping section 15 and deleting the lower section 16, because we think that is satisfactory on its own. When we were meeting over lunch, some additional concern came up for the hypothetical that Phil brought up. So we said, okay, if this is a hypothetical people are concerned about, here is a way to address that. But I don't think that's the crux. The key thing is the section 15 that we modified above.
Okay. And again, I was just trying to understand how this is working, how, as the industry currently functions in other states. And so to your knowledge, there isn't this coordinator out there in another state that is working outside of working with an SO.
So good question. I mean, the registration process varies so much from state to state. I'm not aware. I believe most states, at least where Arcadia is active, most states require some affiliation with the registered entity to market, which means most customers, you can't acquire customers for a project until projects are either being developed or something like that, or at least have applied. So yeah, I'm not aware of people, or there may be a market out there, but I'm not aware of markets again where you can acquire customers without being connected to a project.
Okay. Yeah. So this hypothetical then that is necessitating number 16, I'm having a hard time.
So Your Honor, if I may, there's actually a circumstance which we believe this covers if you have a subscriber organization that markets on behalf of itself as well as other subscriber organizations. So in the event that they are acting on their own as a subscriber coordinator, this we believe makes it fairly clear that they're responsible for their own agents. But because I don't know, I suppose we'll have to figure this out too. We have a subscriber organization that is actually marketing on behalf of other subscriber organizations. Does that make them a subscription coordinator, or does that make them a subscriber organization? This probably will also provide some certainty that they will be in fact covered under both of those if that creates an issue. But I think maybe I misunderstand what Mr. Feinstein's saying. Is I'm not entirely sure that there aren't arrangements that some of the folks in Maryland have right now where they solicit this power of attorney from customers prior to having a subscription for them to sign up for. So, I mean, there are projects that haven't come online yet, but there are folks out there who are marketing, and they're basically saying, well, give me power of attorney, and when this project becomes available, I will sign you up for it. So I thought we were covering that particular outcome as well, and it's not hypothetical as far as I understood.
Okay, well, Mr. Feinstein seems to think that this isn't necessary, and if that's the case for the other developers, the other potential SOs, if they don't think we need 16, for me at this point, it just seems to kind of muddy the water a little bit as to, again, who is responsible. But let me pause here. I'd like to hear the thoughts and questions of Commissioner O'Donnell and Commissioner Linton.
Yeah, the problem I'm having is, with all due respect, staff, Mr. Vanderhayden is saying, well, this covers this situation or this situation. This says none of that. This doesn't cover a subscriber coordinator explicitly who's marketing without being affiliated with a project. It doesn't say that. So
If you look at B, Commissioner O'Donnell, B, the language is distinct between the two, where B in 15 says on behalf of the subscriber organization. B in 16 says on its own accord. So that's how we meant the distinction between selling subscriptions on behalf of an SO or selling subscriptions or marketing generally on its own behalf. So it's on its own accord was the language that was suggested there.
yeah, I'm like Commissioner Richard. The chairman seems to think it muddies the water, and so do I. If we're here discussing this today on August 26, 2021, and we can't figure out what this says real time, what it means, how's it going to read 5 years from now? Or 2 years from now when there's a different set of commissioners trying to administer this COMAR? It just blurs the lines of accountability in my mind. I don't know how.
But I mean,
right now, if you just read 15, it just seems very clear that the subscriber organization that's where the buck stops. And there's, no ambiguity to that. But 16, just sort of, one, I don't get the hypothetical, someone just out there, subscribing people without really being affiliated with anyone for them to subscribe to.
Yeah, I think we should prohibit that.
Yeah, right. After Commissioner Linton, do you have any thoughts here?
Yeah, thank you, Mr. Chairman. Yeah, I agree. I would actually just remove it. The hypothetical that suggested, I suspect you could have a scenario where a subscription coordinator is out attempting to enroll customers prior to signing up with a subscriber organization, and maybe never signing up with a subscriber organization, or maybe that same coordinator intends to sign up with a subscriber organization and there's some issue with initiating the project or completing the project, so the coordinator no longer has an entity to go to. So you now have all these customers and you can't honor the agreements that you've made with them. I think the problem that from a commission perspective is I don't know what type of relief we'd be able to give those customers. If we're saying here that this section means that those customers receive some kind of judgment, I guess, from the coordinator for the loss of benefit in those contracts, so that's not something the commission can do. We don't have the authority to do that. So, I mean, if that were the case, a lot of our supplier in the retail side, a lot of our complaints there would be resolved very differently. We'd force the supplier to actually honor the promise they made to a customer. We're going to give you 60% savings over the life of your contract. And so we penalize them for making the promise, but we don't give a reward to the customer for the loss of that promise. So I mean, I see what's happening. I see what we're trying to get to, but I don't see how we could actually go forward with a solution here.
And for me, it seems like 15 A and B, I mean, that appears to actually resolve the again, any ambiguity about who's responsible. So anyway, just speaking for myself, I don't know where Commissioner Linton and O'Donnell are. I'm fine stopping there and declaring that we have resolved this issue.
Personally, it just feels like we're still trying to make this subscription coordinator or broker analogous to the retail supply, and we don't have a broker situation. I don't get it. I don't get what we're doing here. We wouldn't allow someone on the retail side to go sell and market a product that they don't have a relationship yet to go and sell and market. I don't know what we're doing here.
Yeah. So we want to make ultimately the coordinator to be truly working with a subscriber organization, and that supplier organization is ultimately responsible for any contract or any commitment made to end customers. Does 15 do that? 15A and B.
Your Honor, I think.
CCS Representative Mr. Naidi, is that, or Mr. Feinstein?
Your Honor, yes, that does. It's CCSA's reading and understanding that yes, Section 15 covers that. There may always be entities, operating outside the bounds of the commission, and I don't know how to address them. But I think for the situation that you proposed, and I believe that the issue we were tasked to solve over lunch is solved by Section 15.
Thank you, Mr. Feinstein. So, any other parties? This MEA, OPC, utilities. I just want to make sure everyone has a chance to speak to this issue. If not, I guess it's now up to Commissioner O'Donnell, Commissioner Linton. Are we good to go? This for me, it seems to just going with 15 answer that question about who's ultimately responsible. And here it says it's the subscriber organization. So that
Yeah, I'm good with that, because if we have people out there who are marketing and selling a product that they don't have in hand yet because they don't have a relationship with a subscriber organization, what are they doing? How are they even operating?
Yeah. Commissioner Linton?
Yeah, there's a squares blocked, but yeah, I am in favor of stopping at 15. I think it's if there are parties out there that are doing that type of marketing, and based on what we've heard over the last 2 days worth of these hearings, it sounds like there's something going on, and I'm not really sure what it is, but those entities will have to go through the process to become subscriber organizations. And if they are going to, that's actually, they're going to go through the licensing process of a subscriber organization to become a subscription coordinator. So that will at least place them on the radar for us. And if it turns out that there's some challenge going on there, then this is a pilot, so we can always come back and take a look at this later if we need to.
Okay, thank you. So it sounds like we're agreed that we'll adopt 15A and B, but we will not take 16A and B. Okay, what's the next issue, Mr. Van Hayden?
Yes, sir. I think we need to go and look at the language addressing the clean fill site. So I think we first go up to the definition. Should be around page 3 on the document. There it is. So I think we had some instructions to sort of combine the language that was provided. And so I think we have reached agreement on what the language should look like. There is a minor change with the word closed adding, I'll go through in a second. But so clean fill site means in this case, closed filling operation exempt from regulation for the NDE for that particular section. And then said for which a subscriber organization has provided evidence from a local authority having jurisdiction that the filling operation meets the exemption criteria under 2604/0704. So this is essentially combining the language in the green from the top and then the red language that was added from CCSA. We did add the word closed because we had sort of a discussion as well. The word filling operation might imply that it's actually an ongoing operation rather than something that has been closed. And we do use the word closed in the use of a brownfield for a closed landfill. So we've basically just added these two things together, and we had a little bit of a discussion as to what sort of documentation will be provided. I think there's still a little, perhaps some uncertainty as to what exactly that will look like. But what we have here is essentially, I believe, a definition that everyone is comfortable with.
Okay, thank you, Mr. Van Hayden. Does a representative from CCSA, Mr. Feinstein or Mr. Naimi?
Yes, Commissioner, Chairman Richard, excuse me. Yep, we are in agreement with this language.
Okay, and just so I'm clear, I see an or. Are we talking about the new language that's under the or?
Correct.
Okay, great, thanks. Commissioners O'Donnell, Commissioner Linton, questions, thoughts?
So,
Yeah,
Mr. Chair,
oh,
sorry, go ahead.
Go ahead, Commissioner Wood.
Sure. This looks okay to me. I guess, and I hate to get very legal here. I guess the lawyers may appreciate this on their hearing today, but I see the word evidence in here, and that kind of makes me pause a little bit. So I prefer to see something else there than in the word evidence, because evidence is it's a term of art.
How about documentation?
Yeah, something like that is better. I mean, evidence wouldn't be considered evidence until it's presented to during an evidentiary proceeding. So you can call it evidence if you want to, but it doesn't necessarily mean that that's what it is.
I'm fine with documentation. Commissioner Linton, if you are.
Yeah, I think that's better. It may turn into evidence at some point, but it won't be right away.
Okay. Does that cause any other parties a problem swapping out evidence for documentation?
That was fine, sir.
Okay. Okay, so looks like we are now, I guess we're substituting what's next to 25, and we are substituting that with the language under or. Is that correct, Mr. Van Hayden?
That is correct.
Okay. Okay. Let's anything else?
So we have to now adjust the application. So you see, we now have a definition of clean fill site, and we are going to use that definition in two places in the document.
Okay.
We're going to show where we've changed that. The first section is there it is. So this is the category section, and this is what is telling us how we will describe the types of projects that fit into the various categories. So so A here is the SBO, or small brownfield and other, and we may need to reorder this, but for the purpose of adding the 5 you see there, the B, this is duplicating the language in 3 for projects installed on brownfield locations, but we thought that just to keep it nice and distinct, we would add an additional line that says projects installed on clean fill sites. So this language is just addressing that project may use capacity within the program category of small brownfield and other. And I suppose the other will now include both 51% LMI and clean fill sites. Not that we have to call that out specifically, but that's the name of this category, small brownfield other. So that's the change there.
Okay, and so and that has the effect, as we discussed earlier, that the commissioners, we wanted to extend the same economic advantage to the clean fill as we do to the brownfields. Is that correct?
The economic advantage will show up in the co-location section. What this is doing is it is allowing capacity to be used in the SBO category. So right now, to be an SBO, you had to be small or on a brownfield or 51% LMI. So this would allow a clean fill site to take capacity with an SBO.
Okay. All good with CCSA?
Yes.
Yes. Any other parties? Okay, then Commissioner O'Donnell, Commissioner Linton, what say you?
I'm good.
Good here.
Good. All right.
All right, and the other change, I think that's it. We need to go to the section on co-location. There we go. All right, so in B here, so in A of this section, it just talks about that you may not construct more than one facility on a single property, and you may not construct facilities on adjacent property. And then B talks about the exceptions to that are written into the regs. And so in addition to rooftops, industrial zones, brownfield sites, parking lots and multi-level parking structures, we did not, because folks didn't really want to, I thought it'd be easier and faster just to add clean fill sites to number 3 under B. So it says of a combined capacity not exceeding 6 megawatts. So on brownfield locations, so that's the existing, and then clean fill sites. So we believe that this will allow a 6 megawatt facility to be installed on a clean fill site, or rather multiple projects can be installed either adjacent or on the same parcel, up to 6 megawatts on both brownfield locations and clean fill sites. So we're just adding those 4 words there to extend that economic benefit of co-location to clean fill sites as well.
Right. Any comment from CCSA advocates? Any other party? Not. I turn to Commissioners O'Donnell, Commissioner Linton.
I'm good, but again, I think you're, I shouldn't say ever, but unlikely to ever be able to cite 6 megawatts of solar on a clean fill site, but maybe.
Okay.
Good here.
Good. Me too. Okay. Moving on. Anything else?
I believe that's all the changes we made, right? Yeah, that's
Okay.
it. The lunchtime changes.
Very good. CCSA, did we cover everything from your perspective?
Yes, Commissioner Richard, I believe we have.
Okay.
Chairman Richard, excuse me.
Yeah, the Commissioner is fine. Only I turn back into a pumpkin after this is over. So thank you. Let's see. So, I mean, at this point, I believe we are ready now to formulate a motion. Are there any other issues, okay, specifically related to this this proposed rulemaking? After we've entertained the motion, I understand there are a few other issues that parties may want to bring up, but I'd like to just at this point find out if there's anything specifically that we need to do related to the proposed rules that we're about to consider. Okay. Hearing from no one. Ms. Best, can I, you sent me a motion. Does it reflect everything we have done today? We've specifically, of course, this afternoon.
Yes, Mr. Chairman, I believe it does. I can take another minute just to review it, but I don't think any edits need to be made to the motion.
Okay, can we just take a minute to do that? If you can review it, and I'd also like to send it to Mr. Vanderheyden and Ms. Garofalo. If you could all just review that, why don't we just, how much time do you need?
It should take me no more than 2 minutes.
Okay. Well, why don't we do a 5-minute recess? Could you make sure that Mr. Vanderheyden and Ms. Garofalo have a copy of this motion?
Absolutely.
Okay, and then we will come back in 5 minutes, and once I'm certain that we have the correct motion, then we can proceed. Any other issues, Commissioner O'Donnell, Commissioner Linton, you want to raise before we get ready for the motion?
Lord, no.
Okay. All right.
Yeah.
We'll take 5 minutes, and we'll be back to entertain a motion. Okay, Ms. Best, have you had an opportunity to review the motion?
Yes, Mr. Chairman, I'm getting ready to email you a final copy now.
Okay, thank you. Okay, thank you, Ms. Best. Commissioners O'Donnell, Commissioner Linton, are you ready for me to propose this motion?
Yes, Mr. Chairman.
Okay. Waiting for Commissioner O'Donnell to pop up onto my screen. Okay, Commissioner O'Donnell, are you with us? Oh, one moment. I just have received a text that Commissioner O'Donnell has lost his internet.
I think I'm back. Can you hear me?
Yes, Commissioner O'Donnell. Okay, I was just about ready to read the motion. Are you ready? Ah, there you are. Okay. All right. I move to publish the proposed regulations as modified during this hearing in the Maryland Register for notice and comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements as follows. New regulation 20.62.03.09 and revisions to existing regulations. Point 2 under 20.62.01. Next, 0.01, 0.02, and 0.04 under 20.62.02. Next, 0.02, 0.03, 0.04, 0.05, and 0.08 under 20.62.03. And finally, sure that's correct, 0.01, 0.03, 0.04, 0.05, 0.06, 0.07, 0.08, 0.15, 0.16, 0.17, 0.18, 0.19, and 0.20 under 20.62.05. Vote begins with Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And I vote aye. The proposed regulations are adopted. Okay, with that, are there any other matters, any other issues that parties wish to raise at this time?
Chairman Richard, I would like to, Jake Alciner on behalf of the Maryland Office of People's Counsel, I would like to reiterate the remarks that I made during our opening statement and the recommendation that we included in our comments that were filed on August 20th to seek direction from the commission and hopefully an order from this panel directing the net metering work group to consider changes to the cost recovery mechanism that the utilities are currently using to recover the cost of the net energy metering credits from other non-participating customers within the same rate class as the customers that are receiving the credits.
Thank you, Mr. Oslander. I think this is the time that commissioners, we can to speak with views and any guidance we would like to provide the work group. Personally, I would like to see the work group continue on all of the issues that OPC has raised in their comments. I think these are all important. You know, one probably first and foremost for the report to the legislature, and also for any to inform any future rulemakings we might make to again further improve the net metering process generally, and specifically for community solar. I think they go hand in hand. So I would certainly not want to disadvantage any community solar in any way. So I think it needs to be looked at equitably across all aspects of net metering. But that would be my view on how the work group should proceed in this area. I think the whole national debate over, you know, NEMS 2.0 and 3.0, I think is something that we need to begin to consider here in Maryland. But in the meantime, our legislature has decided to simply double our net metering cap. So I think those are the rules that we operate under currently. So with that, Commissioner O'Donnell.
Yeah, I'm fine. My hope is the work group continuing to work, and they should, including a discussion of bus recoveries, is important, all geared towards a successful refinement of this pilot and the CSEGs that develops into a permanent program, hopefully in the state of Maryland. My greater hope is that the work group product will be more refined and more collaborative and more consensus oriented than we've seen to this point. That's my opinion.
Thank you, Commissioner O'Donnell. Commissioner Linton.
Thank you, Mr. Chairman. So I know this particular work group asking you to continue working on this issue is probably a bittersweet request. On one side, you are very excited about working on community solar and the many challenges and opportunities it presents. On the other side, you've been talking to each other for 5 years now. Probably aren't interested in doing it much more, but there's still more to do. So I would agree with Commissioner O'Donnell and Chairman Richard that we should continue to, you should continue to meet and think through all these additional challenges, and not necessarily because the pilot program is still operating, but because at some point we have to inform the General Assembly about what to do next and what the permanent type of solution, in the event we recommend one, what it should look like. And so many of our state solar goals have changed a lot over the last 5 years. So community solar is going to have a role in some way in all of those goals. And so the work that you're doing now is going to be very critical to helping to shape the long-term community solar goals for Maryland. So I guess the thing I'd suggest at this point is to keep in mind that you're really having two conversations at the same time. You're having one to talk about a pilot program that by statute ends in a few years, and you're doing it within the context of a number of state and national goals and national discussions on solar as a whole. And so it can be difficult and easy sometimes to communicate and mix the two together so that the statewide policies for solar impact and influence issues that we're talking about on the pilot. And sometimes something that's on the pilot needs to stay in the pilot, and other issues that are for the national conversation and the statewide conversation and long-term conversation need to stay there. It's 3 years from now, we won't be talking pilot anymore. So unless it's extended again, which I guess is a possibility, but I think at that point we'll be ready to go forward with something more permanent. So have at it, and I think you'll do, as you've done already, a good job. And we'll see, look forward to seeing what you come up with.
Thank you, Commissioner Linton. If at this
Mr.
point
Chairman.
there are no other matters,
Mr. Chairman.
Mr.
yes.
Chairman.
First, Commissioner O'Donnell.
Yeah, I just wanted to add my thanks. Commissioner Linton reminded me how daunting this work can be, and for all the participants in the work group. I know it's not easy, and I want to give you my thanks for the hard work that you have done, because this is some pretty unplowed ground and pretty esoteric stuff. So thank you all very much for your service in trying to deliver a product in accordance with state policies, state goals, national goals, and keeping the commission on the straight and narrow with our ability to administer this program.
Thank you, Commissioner O'Donnell. Well said. I heard another voice.
Yes, Commissioner, Mr. Chairman, Al Bartlett here. Yeah, I know we're all pretty tired and we all want to stop it. And I do want to appreciate the positive and effective work of everybody during this hearing, and especially thank you and Commissioners Linton, O'Donnell, and the staff for an effective hearing. I do feel that we just need to think a bit more about the issue of cost to ratepayers as we're charging the working group. We had actually anticipated detailed discussion of this issue under the topic of bill impact, because that was one of the topics that staff's comments included. But since that proposal on bill impact cap was withdrawn, we never finished really the discussion. But the way it's been left, the proposal that Mr. Auslander has made, that cost of solar might be shared with non-residential classes of service, is still using the concept of a cost of solar that is the sum of the foregone utility and transmission distribution charges that are based on a centralized model of electricity generation distribution. But that concept doesn't really apply when we're talking about distributed energy resources, including solar. And so it's you yourself suggested, Mr. Chairman, the issue of how the cost and value of solar is determined. It's a policy issue. It has importance beyond the community solar pilot program itself. By extension, it would be applicable to all net metered solar. And we actually know from the studies that the commission itself supported under PC 44 that the methodology for calculating the cost and value of solar, including community solar, has to reflect the complexities of distributed energy generation, including the deferred cost of capacity and distribution and transmission savings that result from distributed solar generation. So that Ms. Miller referred to the Daymark study under PC 44. It did such calculations. It came up with estimates of from 8 to 9 cents per kilowatt hour of value added for behind the meter solar, and 9 to 11 cents per kilowatt hour for utility scale solar. So community solar would fall somewhere in between. The staff calculated with BGE cost data that the combined foregone cost of transmission and distribution to residential class customers is only 5.8 cents per kilowatt hour, less than that value added. And these benefits of solar come from investment of private capital, whether it's homeowners or businesses or subscriber organizations. So they represent a net saving to utilities and a value added that affects all ratepayers. Bottom line, we don't think that the working group should be working with an approach to cost calculation that's incomplete in terms of the PSC's own findings. And because it's both a policy issue and so complicated, we actually don't think the working group has the expertise or the scope to do it. So we actually agree with Ms. Miller's original suggestion that there be a more complete analysis of cost and value added related specifically to community solar projects. And this be carried out perhaps as part of the evaluation, and certainly before we make any decisions about what we would call added cost or bill impact. So thank you.
Thank you, Dr. Bartlett. Your comments are noted, and we appreciate your participation in this proceeding. With that, unless there is anyone else who wishes to be recognized, I once again want to thank Mr. Vanderheyden.
Thank you, Mr. Chairman and Commissioners. I just want to thank everybody in the working group. This has been a tough slog. We've been at this week after week for 5 months and then many months before that. I think we are able to make decisions more quickly once we've sort of consolidated on a policy direction. I think I sort of realized that a little bit over how much we got done in an hour over lunch. So I think we're going to probably try to move forward with these things. Our next big topic for everybody in the working group, we have to design the legislative report that is due in less than 12 months, next July 1 of 22. And I know there's a lot of folks have a strong interest in what that report will say and the type of information it's going to require us to analyze, to put together. So I look forward to getting folks back together. And I appreciate all the effort everyone's done thus far. But as I think Commissioner Linton noted, our work is far from done, and there's a lot more to go to get this program off the ground and moving. And I would say, I think we'll be able to get it done if everybody pulls together in the same direction as we have, hopefully, as well as maybe even a little bit better than we have over the last couple of months. So thank everyone, and thanks to the commission, and thank you for Amanda for being such a fantastic editor of all these different copies. I don't think we could have done this without her.
Thank you, Mr. Van Paden. And yes, by all means, let's make sure we recognize and thank Amanda Best for behind the scenes and in front of the scenes and just doing so much to help us get through this entire rulemaking process. And I also want to just thank all the work group members, people who have put in countless hours in working to help this state policy, not just walk, but hopefully run. And well, we may not be as a state wearing the yellow jersey right now. Hopefully, we're in the leading peloton, and we can continue to be a place that people look to for solar development and around the country. So again, hopefully we've sent the signal loud and clear. Maryland is open for business for solar energy, and hopefully we've also sent the same message that our solar policies are open to all Marylanders to fully participate and benefit from these important actions we're taking as we look to climate change and also just environmental improvement. So again, thank you everybody, and this proceeding, this rulemaking is now adjourned.